Good afternoon again. Welcome to the Appellate Division First Department, or arguments for today, April 15. I hope you all filed your taxes or an extension to file, so there are no issues. So we have almost 7 hours of argument time requested. Obviously, we will not be able to exceed to that. So please ask for the time that you actually need in order to get out the salient points of your argument, okay? Keep in mind, we have read your briefs. We are fully familiar with your arguments. People v. Victor Augustus. That matter is submitted. Green v. City of New York. 524, matter of baby girl. Yes, 2 minutes. Burkovich v. Judaw contracting. 525. TNA Insolvency. They requested 5 and 3. 525. People v. Anthony White. 515. Timmons v. Prelo. That matter is submitted. 2512, 7th Avenue versus Webb and Brooker, Inc. You represent who? Webb? And who do you excuse me? 2512. Oh, 2512. And go ahead. So you didn't request any argument time? You're 2512? Yes. Okay. So I have that you requested time, and I have that Webb and Broker did not request any time. Okay. How much time are you requesting? 5 and 3, please. You have a cross claim? No. I'm sorry? 5, 2, and 5. Dov Kip. 524. People v. Cordero. That matter is submitted. Jab Building versus 953rd Avenue. 5 minutes and 2. 525. Where v. Where? 525. Joseph v. New York City Department of Housing. 525. Zurich American versus Providence Capital. Who do you represent?
I represent Providence Capital. I'm asking for 5 minutes.
There's no appellant. You still want 5?
I'll take 3.
You'll get 2. Saxby Rent-A-Crate Enterprises.
For the appellant, requesting
412. McLaclin v. Air and Liquid Systems Corp.
request 5 and 2, Your Honor.
Good afternoon, Your Honor. Respondent, request 5.
525. People v. Massapanero. That matter is submitted. Guerrera v. HPSONY Inc. The matter is submitted. First case for argument is Green v. the City of New York.
Step up.
Yes.
Thank you. May it please the court, my name is Jay Breakstone. I represent the appellant, Joanne Green. We're looking at 2 orders dismissing this case essentially for failure to proceed. This is the end, or maybe the beginning, of a 5-year battle for discovery against the Housing Authority. It's been 5 years since the initial combined demands in the D&I was served in July of 2018. And the result of that initial discovery, D&I and combined demands, were 4 work tickets. This is a woman who was on the stairs that were flooded due to a...
Yeah, so the Housing Authority provided the documents, the log, and other documents to you, did they not?
Yes, after 4 years.
And what was the issue therefore?
Well, the fact is that there is still discovery outstanding.
Counsel, you got the work order that shows that there was a flood on the day of the accident, right? And you got Mr. Ortiz's EBT, right?
Right?
So what else do you need? That's basic stuff for.
Well, but that's not all of it, Your Honor, because the liability here is that the housing authority did not do what they were supposed to do in a timely fashion. And the reason they didn't do it, Your Honor, is
What were the Jackson affidavits they gave you?
they're horrible and they're ridiculous. And they don't,
Described like a search, electronic search and a physical search.
and the first Jackson affidavit says we searched and there's nothing. There's nothing more than what we gave you. And then after that Jackson affidavit was filed, there was something more. In fact, that's what's always happened in this case.
But
Every time
ultimately, as my colleague just stated, you received the documents.
we
And
didn't,
you also were able to take the deposition of Mr. Ortiz, I believe.
but we didn't receive all the documents. We didn't receive the documents we asked for. We didn't receive the documents that had to do with whether or not the speedy valve was stocked. The speedy valve is the valve that saves flooding and things like that.
How do you prove a negative? How do you prove a negative, however, if there's two affidavits indicating that a proper search was done of both electronic and physical files, how do you prove a negative but other than providing a Jackson affidavit that sets forth your search?
Well, but the Jackson affidavits, the first affidavit was incorrect, Your Honor.
Okay, so we have the second
We
affidavit.
have a second affidavit. It's just as incorrect, because the fact of the matter is, there's no way to test the Jackson affidavit if we don't get the discovery.
Exactly. Well, no, the point is, how do we know that that second affidavit stating that those documents do not exist based upon their search, how do we know that that's not true?
It's almost, well, I'm almost tempted, Your Honor, to say, how do we know it is? The fact is that the track record of discovery in this case shows that every time.
So you don't believe that it is correct because of the track record and because, no disrespect to NYCHA, they have a history of not telling the truth in these affidavits? You have Mr. Ortiz's deposition in that he testified as to the speedy valves, when they are replaced, when they are not replaced. He also stated that he did not recall whether there was any work ordered for that period.
Yes, I mean, Ortiz said that they're essential, and this is, by the way, is now May 20 of 19. That's how long it's taken. The speedy valve is essential.
Right.
And it's kept in a storage room. Now, he doesn't know whether it was there. He doesn't know whether there were any speedy valves stocked. He doesn't know anything other than the fact that he filed the order.
Right, but in terms of
That's all he
reports,
knows.
in terms of reports, he stated that he did not know whether there had been a work order as to the speedy valve in terms of in November of 2012.
Right. He knows that he filed the request for the speedy valve.
Right, so
all he
his testimony in conjunction with that second Jackson affidavit, why is that not sufficient to show that those documents don't exist, or at least they can't find those documents?
Well, the first, I mean, Your Honor could have made that argument at the first Jackson affidavit. The first Jackson affidavit said very clearly, we don't have the items you want. And of course, then
Counsel, is the crux of your appearance here today a request that sanctions be applied, or is this a situation where a jury's going to have to determine credibility based on what was produced, what wasn't produced, and the contents therein?
I'm tempted to say yes, Your Honor, but of course, that's what juries always do. What
No,
I'm saying,
it wasn't. I don't think that question was a yes or no.
I know it
I think it
wasn't.
was, but you can think about it and reply on rebuttal. Thank you.
Good afternoon. May it please the court, Patrick Lawless for defendant respondent, New York City Housing Authority.
So the first Jackson affidavit apparently was incorrect. Now we have the second Jackson affidavit.
I don't think it was incorrect. It just didn't, it wasn't found to have sufficient information, and that was supplemented by the second Jackson affidavit.
Well, did the first one say those documents that don't exist, and then the second one say, oh, yeah, here they are?
No, they both affidavits say these documents don't exist. And let me just be clear. This doesn't have to do with any prior discovery. It doesn't go back to the initial demands. This has to do with the plaintiff's demand that was made in July 2022, which is 4.5 years after the accident, for records pertaining to the acquisition and purchase of speedy valves by NYCHA. That's what this was about. There was a compliance conference, and at that compliance conference, after the initial Jackson affidavit and NYCHA submitted the second Jackson affidavit, then there was a disagreement whether the second affidavit was sufficient. Then the court said to the plaintiff, it says in the order on page 826, make a motion for a Jackson affidavit. Not make a motion to strike, just to see whether there's a further Jackson affidavit. So all the other issues that the plaintiff talks about with respect to discovery are completely irrelevant. And this was resolved. Then ultimately, the court found that the second Jackson affidavit was sufficient with all the other discovery that was provided by NYCHA. And there is absolutely no basis for the extreme sanction that the plaintiff is seeking here. Unless the panel has any further questions, I'll rest on my brief.
Thank you.
Thank you.
Your Honors, the fact is the initial discovery request in this case asked for all the documents that it took us 5 years to get. My colleague is incorrect. The
You're seeking the striking of the answer, correct?
That's correct, Your Honor.
Okay, and what's the standard for striking a pleading?
But in the alternative, Your Honor, and I think this.
I'm sorry?
I said in the alternative, Your Honor.
You're seeking striking of the answer in the alternative.
No, I'm saying, Your Honor, is that other than striking the answer, right, which I think should have been done, I think maybe it's more realistic to allow discovery to continue while this case is on the trial.
But my colleague's question to you is, what is the standard for striking an answer? What do you have to show?
Well, I think you have to show willfulness in failing to answer honestly. Now, I can make that argument, and I have made the argument in the brief, that 5 years of chasing the same documents with denials that they don't exist, only to find out that
Willful violation of the rules, willful and contumacious violation of the rules. That's what the standard is.
And that's
So
what happened.
how does the record bear that out? I think that's the question my colleague was getting to. How does the record bear that
Well,
out?
the way it bears it out is that when you ask for documents and you're told they don't exist, and then you discover 4 or 5 years later that one individual by the name of William Schwartz, who works for the Cardinal Claims Service, is the guy who's been pulling all these documents for 4 and 5 years. So every time the Housing Authority said a document didn't exist, and William Schwartz knew or should have known that it did exist, that's a problem for the Housing Authority in terms of fighting this case. William Schwartz is the fellow who did this. He was the Cardinal Claims Service. This is one individual who pulled every document.
But he stated that he searched in the documents, he could not find the documents, right?
Well, that's what they said. That's what they said the first time. But the fact is that wasn't true. It wasn't true the second time. It wasn't true every time they said it. Because even after they filed the second affidavit, additional items came up, like the Kronos log clock records of who accessed what at what time.
Thank you. Thank you both. Matter of baby girl. Watch out.
Just let me know when.
Yeah, so you are the respondent, is that correct?
Yes. Neighborhood Defender Service of Harlem by Michael Weinstein on behalf of Mr. A. Greetings, Justices, and may it please the Court. Here we have perhaps, especially here in April, the perfect law school exam question, issues of both mootness and ripeness. The issue that's moot is the first order appealed by the appellant, which was mooted out by the subsequent custody order, which at this point is itself not ripe because the appellant has in fact filed supplemental custody applications in the family court that are still pending. Any issues that the appellant seeks to resolve should be resolved by the family court on those petitions that have been filed and are presently before the court. I'm happy to answer any questions that the court has.
Thank you very much.
Thank you so much.
Burkovich v. Judaw Contracting.
Good afternoon. Tom O'Connor for the defendant appellant, Coney Incorporated. 3 years ago, this court had ordered that the plaintiffs claim that software, circuitry, controller, or other componentry of an ES-373 elevator at the South Ferry Station for the Transit Authority was insufficient to denote or indicate or specify a defect in that escalator for a design defect claim. 3 years later, in opposition to summary judgment, their expert came forward with evidence that states the same exact thing, that the defect in this case is software, circuitry, controller, or other componentry. They have not, according to the law of this court, they have not stated a design defect claim, and it should have been dismissed.
Counsel, what about the affidavit of David Birch, where he says, and I refer to the record at 2222, I witnessed the start and run of the cone trans 180 escalator without utilizing a start-stop switch key or a handheld pendant box during one of my training classes. So here, to the extent that one expert says you cannot operate this escalator without human intervention, and the other one says, I saw it with my own eyes, isn't this something that a jury has to decide?
It is not, Your Honor, and for a very simple reason. The trial court and this court are the gatekeepers of scientific information. You cannot present that to a jury. You cannot present anecdote and say it's methodology. You cannot present history that's not proven. He doesn't give an indication of when it occurred. He doesn't give an indication of how it occurred.
Isn't this more by way of direct evidence? I saw it happen with my eyes?
Your Honor, not when it comes to the defect, because he also refers to that affidavit. He refers to the indication that it was David Proviano, his student, that he was working with when that happened. That is not indicative. David Proviano was deposed in this case. It has to be substantially similar. If it's a prior condition that he's claiming is an indication that the trans 180 escalator has a defect that starts, that's fine. But he must come forward with evidence that it's substantially similar. Proviano testified in this case that he was using a handheld pendant control, that it was in inspect mode, that it had nothing to do with what the indications are today, and it was on a different type of unit. It wasn't on the Trans 180, the ES-373 model that is with the Transit Authority in New York. It was a model that was WMATA.
Is there anything to the affidavit of the plaintiff's expert in terms of the timing, this 3-second issue, as to whether or not it was humanly impossible based upon the location and the time? What do we make of that information?
Two things on that, Your Honor, because if you turn to page 62 of the brief for the plaintiff in this case, they make two different arguments with respect to where Mr. Wallerson is at the time. When it comes to whether he turned the key or not and started it, as he told investigators that morning, they say quite clearly at page 62, indeed, Wallerson repeatedly confirmed that he was right at the entrance of the motor room at the street level. So with respect to whether he turned the key or not, they want the fact to be that he was at street level. And they state in their brief, he was at the street level. And now they want also to say, oh no, he was down in the motor room and he turned it to inspection.
Well, is there a reasonable view of the evidence that would support each of those scenarios?
The only reasonable view, Judge, with respect to where Wallerson was at the time of the event, was at the street level. That is uncontested fact in this litigation. And so they want two things then with respect to what goes on in the motor room. They want it to be inspection mode, and then they're using the LiftNet report. And I've given the court below and here, the LiftNet report does not record timing in the real world. It does not operate like that. And the fact that they've used it and the fact that they've relied upon it subverts their entire case from a factual
Go
point
to
of view.
paragraph 13 of the plaintiff's expert's affidavit. The expert indicated that LiftNet was capable of denoting or connoting a timing of events.
Sure, Your Honor, and this gets back to what Mr. Murch has said in all of his opinions. I had an experience in the past. It's incompetent, Your Honor, as a matter of law, because this LiftNet report at this location, at the South Ferry Terminal, on June 24th, 2017, was designed by Tony Boom, and it doesn't operate. LiftNet is an independent company. I'm sure they may have a system somewhere that records the data right off the controller of the escalator, and could give you a chronological order. This system was designed by Tony Boom. We've given them the computer code. We've shown them how that system operates. It does not record real-world events in real time. It cannot.
Thank you.
Good afternoon, Your Honors. Brian Isaac. I represent the plaintiff respondent. Before I get into my adversary's argument, I just want to note one thing. You know, I had a professor in law school who told me that lawyers' biggest mistake is that they always read what's there, but they don't read what's not there. And I think he was really talking about what I call negative implication evidence. If you look at my adversary's brief, the main brief, it's spectacularly good. He's able to discern and to make clear, complicated problems that are very, very difficult to understand. And he does so in a way, and I'm sure you know because how you read the citations, he actually cites to the mechanical drawings, which I can't figure out for the life of me. If you take a look at his reply brief, it's equally good, except there's something missing. And in his argument, he left it out also. That's the design defect claim. I'm going to get to the phantom starting claim. But if you look at the design defect claim, those are independently actionable causes of action predicated upon the small size of the step and predicated upon that red button that you see in the pit, which is literally covered with a cable.
And the plaintiff's expert, in fact, details the design defect in his affidavit.
Detailed it in his affidavit, and Your Honor, Judge Pitbrook supported it with the very photos that you see. If you look at that step, you can get your heel on that step. My adversary says that the plaintiff didn't say he fell because of it. That's just not true. He didn't know exactly where he fell, but he certainly said he fell because he couldn't get access to that. And as well, he even said that when he first went to the pit and he contacted that red button, he had trouble moving it. So these are independent claims that would stand alone, even assuming that it was impossible for this to occur, which is what my adversary says. So I would ask you to take note of that as well. Now, let's talk about this phantom starting thing. As Your Honors noted—
Would you concede at least that the defendant's experts made out their prima facie case? Because you say that Justice Nervo said they didn't make out their prima facie case, but I don't think that's what he exactly held. He just said there were many issues of triable fact. He didn't really talk about burden.
Yeah,
I mean, would you concede that the experts made out the prima facie?
I think they made out a prima facie case based on the three experts. You have McLaclin, you have Boom, who's the main expert, and Halpern. I think what he was saying, I think he was intermixing a bunch of different points. But if I can, just let me talk to you about the phantom starting. As Your Honors pointed out, our expert said he actually saw it. So it can happen. Now, my adversary is going to say to you, because he's a very good lawyer, he's going to say that that was at Washington, that wasn't here. But the fact is, elevators and escalators are never supposed to start on their own. So we know it can happen. We know he said he saw it. Here's the situation. Mr. Wallison's testimony clearly was not great, but he had no recollection of putting in the key. He had no recollection of even talking to anyone. He had no recollection of where the plaintiff was.
The second time. The first time he recalled what occurred.
Yes, but if you look at his statement, the C2 statement corresponds directly to what the plaintiff claims. And here, my expert says that the LiftNet system is, in fact, capable of recording things in a temporally relevant situation. Now, Boom certainly says that he was the designer, and he says that it's not, I think the word he uses is asynchronous, a great word, I never heard it before, right? But he never said that it couldn't be temporally relevant, and if you look at what actually happened, it actually does correspond to what occurred. So I think on every single theory, the trial court got this right. He may have a great case at trial. His experts may impress the jury, and he may win the case. But on a summary judgment motion, when you have to construe the evidence in a light most favorable to the non-moving party, I think the trial court got this right, found multiple issues of fact.
So am I right in understanding that the plaintiff's argument is that the database, the data system, I kept writing here LifeNet, but it's
LifeNet.
LifeNet?
Yeah.
Okay. It's not chronological, therefore it can mix up times or events out of sequence?
That's what Mr. Boom
That's
says.
what-
that's not my client's.
Right,
claim. My
whereas the plaintiff's expert says, to the contrary, the data is recorded chronologically, it's not mixed up, and this issue of having a gap in time is irrelevant?
Yes, he says, in this case, given what happened with respect to the facts that underlie this plaintiff's accident, the LifeNet data is congruent with real-time approximations, even if it might not always be. And I think that's the point. And I didn't see in Boom's affidavit, maybe I didn't read it closely, you probably read it more closely than I did. I never saw him say that the LifeNet data could never be congruent with real-time stuff. He certainly said it wasn't necessarily, but I never saw him say it couldn't be. I'm sorry I went over my time. Thanks for listening.
Thank you.
Your Honor, I'll address your question first.
Please, because it's most unusual that a system that is designed to accumulate data and record it would do it out of sequence.
Sure,
Thanks to a time lag.
And if you read Mr. Boom's report, he actually worked with the Transit Authority to design that system. The Transit Authority had a problem gaining fault information data. That's what they wanted. They didn't want a system. If you go to the Kone ES373 escalator controller, it'll give you a list of everything that's happened with that machine for 99 fault codes. So what happens is they have multiple escalators along multiple stations, and they have a LifeNet system at TA headquarters. That TA system runs through all of the controllers, and it pulls out information. The actual escalator clears every 10 milliseconds its fault data. The LifeNet system circulates every seconds to minutes. And so what happens is TA came to Mr. Boom and they said, we need a system that just collects fault data, because that's the information we want.
You said false?
Fault data. So
Oh, fault.
fault data. So there was a specific requirement. And we gave them the computer code. The computer code is attached to Mr. Boom's analysis, which shows this is the system that was in place at that station at that time. It has a specific computer software program that only lists fault data. It doesn't record chronologically events that occur. It has no capacity to. Mr. Murch in his affidavit, their expert, simply says, I worked somewhere, he doesn't say where, at some time, doesn't say when, where I worked with a LifeNet system that recorded data in a chronological order. That's not the system that's in place at the South Ferry Station. And the fact that he just says it as an expert and just says, ipsit dixit, I saw it once, it could be here. He had an obligation to come forward with expert proof that looked at that computer program and said, no, it can be something different. He didn't. There is no evidence in this case, none, that there was ever an inadvertent start. Can I just have 1 minute, Your Honor?
No, that's it, but thank you very much.
All right.
TNA Insolvency.
Good afternoon, and may it please the court. Margaret Rogers with Arnold and Porter on behalf of Plaintiff Appellant TNA Insolvency IPERL. This action to enforce a foreign country money judgment was timely commenced. Section CPLR 5303D requires that an action of this type be commenced within the earlier of two time periods. The first, the time during which the foreign country judgment is effective in the foreign country, and the second, within 20 years of the date of the foreign country judgment becoming effective in the foreign country. This is essentially a codification of New York's borrowing statute. And the purpose of that is to prevent an out-of-state plaintiff from taking advantage of a longer statute of time, a longer statute of limitations in New York than they would have enjoyed at home. And you can see—
Like it's almost an embodiment of the savings statute. I mean, it's like a statutory embodiment. Some people think we do that because we want our judgments to be enforced in other countries, and some non-common law countries want a statute. And so now they have a statute in 5313, right?
That's correct, Your Honor. And in this case, this action was commenced while enforcement in Romania would have been effective. We could have commenced this action in Romania and it would have been timely. And we know that because Romanian Civil Procedure Code provides for a 3-year statute of limitations. But every time you take an act to enforce the judgment in Romania, it interrupts and restarts that statute of limitations.
Was that point conceded or disputed by your adversary?
I think it's effectively conceded, Your Honor. There's no dispute that the acts of enforcement that are in the record occurred, and there's no dispute that the effect of those acts of enforcement in Romania extended the period of time to enforce in Romania. What the defendant's own Romanian law expert said was that the bailiff's evidence of the enforcement actions in Romania extended the 3-year enforcement deadline in Romania only. That's in the record at 739. So all of the Romanian law experts agree that the acts of enforcement, there were 3 of them, one on January 31st, 2019, the second on February 16th, 2021, which extended it then to February 16th, 2024, and the last, September 22nd, 2023, which extended the statute of limitations in Romania until September of 2026.
So if the experts can agree on that particular point, that there is a vehicle in which Romanian law allows for this extension of time once an action is taken every time it extends it another 3 years. If they can agree to that, then if we apply 5303D to that.
We're done, Your Honor. The Supreme Court just looked at the wrong question. They didn't apply 5303 correctly, and the judgment of Supreme Court should be reversed and it should be remanded for further proceedings.
What do we do about the TRO if we agree with you?
The TRO should remain in force and effect, and
You've never had an adjudication on the attachment, though, right?
we have not had an adjudication on the attachment. There was a hearing on the order to show cause. The other side had an extension of time to put in opposition papers. They had an opportunity to put in a surreply. They argued it. So there's been a hearing, but the court didn't really reach that question because they determined that the action was untimely and therefore no provisional remedies were upheld. If there are no further questions.
Thank you.
David Marcus for Appellate. May it please the court, Your Honor.
Do the experts agree on that particular point, that Romanian law allows for a refreshing of the statute of limitations every time an action is taken?
It's not a statute of limitations issue. The Romanian, our expert said that 706 has the very firm statute of limitations that has to be complied with, which is 3 years. If nothing is done within those 3-year period, then the judgment can't be enforced. But our expert showed, and this, by the way, this was not argued by the appellant in its initial moving papers. This was our initial moving burden. We did not have that obligation. This was their obligation. They didn't even address the enforceability of the Romanian statute.
Counsel, would you agree that there was enforcement action in Romania in 2019, 2021, and 2023?
Well, actually, I don't know, because, and our expert explained that the way that the evidence was submitted, what the bailiff said in terms of producing the evidence, or trying to produce the evidence, does not have the ability to opine on Romanian law and state what the effect of the statute was.
So you don't know?
He doesn't have to talk about the legal effect. He just has to say about the factual question about whether or not there were enforcement attempts, right? And didn't he say that?
I believe what our expert said was, regardless of whether there was an attempt in Romania, if there were, that does not change the fact that the ability to enforce in other jurisdictions
Right. No,
outside of Romania
that's your
had
central
expired.
argument. Yeah.
Counsel, how about answering my question?
I'm sorry.
How about answering my question? Answer my question, please.
Could you repeat the question?
2019, 2021, 2023, were there enforcement actions taken by the plaintiff as indicated by your adversary?
I believe, again, I don't believe my expert stated whether or not that happened. I believe what my expert said was it was regardless of what happened, regardless if that happened, it did not extend the time here. If
Yeah, I
the
want you
court
to
takes
focus
judicial
for a
no-
second on it.
Yeah, do you need expert testimony to make that determination? Isn't that just factual? It's based upon what occurred, the facts. So you need an expert to state one way or the other?
I believe you're at that point. I mean, I'm not going to concede that that was done properly or that it was done right, but the documents were submitted to the court on reply, not in the initial moving papers. The court shouldn't have even considered it. But if the court finds that that was an attempt of
It's a
enforcement,
yes or a no. You can go one year by one. 2019, yes or no. 2021, yes or no. 2023, yes or no. Was an enforcement action taken by the plaintiff in any of those years?
I believe there was an enforcement action attempted in 2019, which is what started right after the judgment became final. And everyone concedes the judgment became final on October 2nd, 2019. It's just that what we're saying,
And in 2023, there was an attachment, I believe.
the attachment was in October of
sale.
2023, which was late. And part of what we showed is that the attempts, regardless of what happened in Romania, and this is what we attached part of a case, would show that in that case, the attachment proceeding was timely in Romania, was ongoing in Romania, but the plaintiff in that case attempted to enforce a judgment.
Okay, here's what I want to focus on for a second. One way of looking at this, which is the way I think you've looked at it and Supreme Court seemed to analyze it, is was the action timely based on the law of Romania? What I want you to focus on is, was the Romanian judgment enforceable in Romania at the time the New York action was commenced? Was the Romanian action enforceable in Romania?
I mean, for me to admit that, the reason why I'm reticent to admit that is because that was a last-ditch argument that they made on reply. It was not really fully addressed. And Mr. Taru, their expert, attached documents, and then at oral argument, this wasn't fully addressed. So
Did you get a surreply? I forget. Remind me.
we did get a surreply over the objection of over the appellate.
So, I mean, the obvious point is then you could respond to the argument that they made.
But there, and we did. But the point what we made,
You did. So what was your response to that argument?
the response to the argument again was, regardless of what happened in Romania, the extension, there was no extension in that did not affect the extension.
So you didn't respond to that specific argument. Although the argument was made, you did not respond to it.
I believe what we said was, besides being irrelevant, was that the evidence that was submitted was insufficient to support what they were arguing.
That's all right.
This was a throwout argument that took maybe a page and a half of the appellant's brief.
I'm just wondering, in light of your statement, regardless of what happened in Romania, if these enforcement actions weren't brought there, how do then we reconcile that with 5303D?
Because 5303A and 5303D and laws of international comedy require that we apply Romanian law to see whether or not the civil decision is enforceable.
This is a product of the 2005 amendments to the Uniform Foreign Judgment Recognition Act. So we adopted that in 2021, with one minor exception that's immaterial for our purposes. And there the language which we take, which is, I think, been adopted by roughly 29 states, is the formulation is the earlier of the time during which the foreign country judgment is effective in the foreign country or 20 years from the date. It doesn't ask us to apply comedy in a broad sense. It asks a specific question. Was the foreign country judgment effective in the foreign country on the date the New York enforcement action was commenced?
Correct.
But instead, you want us to apply the net of all Romania's statute of limitations laws to determine whether it's timely based on an action brought here. That's a different question from whether, at the moment this action was commenced, the judgment was enforceable in Romania.
Right, and that also includes 5203A, which specifically does say that the civil decision has to be enforceable under Romanian law.
Well, that's why we're asking these questions as to whether or not it's fleshed out in the record as to whether the judgment would have been effective in Romania at the time the action was commenced. And they brought it up in their reply. Did you, in your reply, did you say this is correct, this is incorrect?
What we did was our expert addressed the different sections that their expert was addressing and explained why that was irrelevant, and all the statutes that they brought
So
up.
you punted.
We didn't punt. We addressed specifically the section.
So by not responding to their statement that it was effective in Romania at the time it was commenced, you're conceding. There would be a concession, would it not?
Your Honor, I don't believe it's a concession, but what I do believe is that we were addressing the issue that was raised, that they're saying that the statute.
Well, you may not believe that it was a concession, but legally, would it not constitute a concession because you did not specifically reject that or state that that was incorrect?
To the extent there's a concession, the concession would just be that perhaps in Romania, if the action that was brought there is still enforceable, but not that Romanian law prohibits a party from trying to enforce a judgment in another jurisdiction if it's not timely. If I could just address the TRO section for 1 second.
You're actually out of time, but thank you.
I can refer Your Honor to my brief, which explains why the TRO must be vacated.
Yes, thank you.
Your Honor, I just wanted to provide the record citations to the evidence showing the enforcement actions in Romania. That's in the record from pages 463 to 468. They're certified translations of Romanian court decisions. The SIR reply that addresses this argument is in the record at page 633. It says, defendant did not argue that the civil decision cannot be enforced in Romania, as that is irrelevant to this enforcement proceeding. And finally, I would like to draw your attention to this court's decision in C-Trade versus Katsudanis, which the court made very clear that there is nothing in CPLR 3213 that prohibits a plaintiff from putting in supplemental papers to demonstrate that their motion for summary judgment in lieu of complaint has established their right to relief.
Well, it seems like what happened here is your client didn't recognize that part of its prima facie burden was to demonstrate compliance with 5303D. So the bailiff's affidavit really was focused on whether there was a final judgment for the purpose of 5302A2. But there's two other components to that. It has to be conclusive and it has to be enforceable. And the enforceability, as your friend pointed out, which I think is clear from the legislative history of this act, the compliance with 5303D relates to enforceability.
I actually disagree, Your Honor. 5302A addresses enforceability, and the rest of that clause says, is this judgment enforceable even though an appeal may be pending? So the enforceability—
That's the finality. Enforceability goes to what the drafters of this referred to as the 5303D statute of limitations. And I think that's also clear from the fact that the defendant only has the burden under 5304 to demonstrate that one of the enumerated grounds for non-recognition apply, and nowhere in that enumerated list is statute of limitations.
5303D does not state who bears the burden. 5302A states that the plaintiff bears the burden to demonstrate that that applies. 5304 states the defendant bears the burden. And traditionally under New York jurisprudence, statute of limitations is an affirmative defense to be raised. And so if you look at the plain language of 5302, it talks about finality, conclusiveness, and enforceability even though an appeal is pending. It's not actually clear that that includes a requirement that you demonstrate prima facie that the action was timely commenced. Either way, we did that in reply, and that was appropriate and within the court's discretion.
Thank you. Thank you both.
Thank you.
People v. Anthony White.
Good afternoon. Rena DiFrancesco for Mr. Anthony White. May it please the court. Mr. White was not adequately informed of a trespass notice barring him from entering Dwayne Reed's stores. There's a multitude of facts that—
We have was there a video of the actual conversation?
So there is a lot of video evidence here. There is a body-worn camera by one of the officers where the officer himself states that this form was read to Mr. White on footage, but this—
Right, so we have the video, all right. We have the statements, the testimony by the various individuals, and we have the defendant's statements, right, at trial? He testified as well?
Yes, we have all.
So all of this was presented to the jury, and the jury made a determination as to who they believed or who they did not believe. And so it was credibility, which was presented to the jury. They made their determination.
Yes, so we are asking the court to look at this contradicting evidence, and specifically to your question, Your Honor, about the body-worn camera footage. The officer had testified that he believed that this notice was read to Mr. White on the footage. It's almost 8 minutes of footage. We don't see anyone introducing this notice to Mr. White, let alone reading to it.
See at some point that the notice had been filled out, though, right? That was visible from the video?
I'm not sure if we see it filled out on video. It was introduced in evidence.
Not them actually filling it out, but there was a document.
The completed form on the video, other than the signature, right? Because he never signed it, right?
Yes, the form itself was completed minus the bottom part, and it was not signed. There's a bottom part of the form that's supposed to be ripped off, a copy given to the person, and this was not given. Mr. White did not receive any copy of this notice, even though the form itself instructs to do so. So even though part of the form is filled out, the entire bottom part is not filled out. And so Mr. White never received a copy of this notice.
Here's a question in my mind. One, is this simply a credibility question that was determined by the jury to the extent that the assistant manager at the store, as well as the police officer, testified that they gave him a summary in one case and then read the form in the other, right? We have that, and then the question is that enough? Assuming for the sake of argument that an oral version was provided, is that sufficient to give notice to someone that they may not return to the store that they'd be robbing from?
So in this case, there's a lot here in addition to that. As mentioned, there is different testimony, as you mentioned, Your Honor. The clerk testifies that she doesn't believe anyone read the notice to.
But the issue is whether or not the defendant was aware of the fact that he was not to return to a Duane Reade or Walgreens, I believe, that he was not to return to those locations. That's the only issue. So the question becomes, was the evidence sufficient to establish that he was on notice that he was not to enter Duane Reade or Walgreens?
No, Your Honor, the evidence was not sufficient.
Why not? Again, why not?
This was allegedly all happening while Mr. White was being handcuffed and arrested. Again, he didn't receive...
And this was also after, what, the 7th time he had entered into a... how many times previously had he entered into a Walgreens or Duane? 7 times previously he had entered into a Duane Reade and taken property?
So the store clerk had testified, she was aware of the defendant, but no one had ever told him that he couldn't. Well, he was never informed formally, like with this notice.
It is important that you be told formally you're not to come to this Duane Reade and rob us and take property, right?
It's important for someone to be aware that if they were to return to a store that has, hundreds of locations throughout the city, it's generally open to the public, that they would be facing...
So I'm sorry, I interrupted you. What in the record or what is there to show that he was unaware, based upon what the video shows, based upon what he was told by the store manager, that he was unaware that he was not to enter a Duane Reade or a Walgreens?
Yes, so Mr. White himself had testified that he was not aware, that no one had explained this notice to him. Additionally, he has shown pretty significant symptoms of mental illness. We see this in his trial testimony, as well as letters that he had sent to the court pre-trial. And this just all together with other factors we have here, the fact that he never received a copy. There is so much contradicting evidence as to whether anyone had actually read the notice to him. We don't see it on any camera footage. He had not signed it. He was being handcuffed. Just all of these specific facts in this case show that he was not adequately apprised of the fact that he was not able to return.
Thank you.
Good afternoon, Your Honors. May it please the court, Connor Burns for the people. Just to pick up with your question, Justice Gonzalez, oral notice certainly is enough to put someone to satisfy the elements of third-degree burglary. All that's required, the penal law states, for someone to be know that they have no lawful entry, is that a lawful order to not remain or enter is personally communicated to them. That certainly was established here by both the assistant store manager and the police officer's oral directives to the defendant. So he's brought back into the store after he leaves on July 9th, 2019. The store clerk, the assistant manager, gets the trespass notice, fills it out in front of him, tells defendant, you have a trespass notice, and quote, that he is not allowed to come back in any Duane Reade store due to the fact that he is a shoplifter. The officer also says, quote, that he's no longer welcome back into Duane Reade, any Duane Reade, and that if he does, he'd be charged with the according crime, and then the officer reads the trespass notice to him, which reiterates those directives.
That's based upon the testimony, or is that based upon the video?
That's the testimony, and certainly it's as Your Honors have noted, that this was a credibility determination. The people presented their witnesses, the defendant also testified, and clearly the jury credited the people's witnesses over the defendant, and that's certainly owed deference here.
So is there a heightened obligation when the person has mental illness? You know, to the extent that this person has been hospitalized repeatedly, something that the store manager probably did not know, but perhaps could surmise from his behavior. Is there anything that we should be aware of?
I think it would be unfair to place a burden like that on the store manager or
How about the police?
I think that might be an argument to be made at trial, certainly. I don't think it places a higher burden on a Duane Reade employee, and that certainly was something I think that counsel argued at trial, and ultimately the jury, in light of that, still found the defendant guilty. And I'll just address the body.
Sorry, but was there any evidence from whatever the source may be at trial that indicated to the police officer or the store personnel that the defendant was laboring under some mental disease or defect?
I know there was testimony that the store clerk was familiar with the defendant, that he had visited the store a number of times, but I don't think there was any direct testimony at trial to show that at the time he was being read these directives that he was suffering from some sort of episode or had some sort of issues that would have affected his ability to understand.
The form asked for the individual's name, date of birth, and address, pedigree information, right? And so that was given to the store manager. That information was given to the store manager from the defendant, right?
It was, yes.
So there's nothing in the record to suggest that the defendant did not understand, to the extent that he did not understand to give his name, date of birth, and address.
Certainly. So he was certainly, again, able to relay that information, which would then suggest he...
And again, any conversations wherein he's relating this information, there's nothing in the record to suggest that that gave any hint to the store manager or any indication to the store manager that perhaps the defendant was in fact laboring under some type of mental disease or defect.
Certainly not, no, Your Honor. And just if I could briefly address the body-worn camera. Certainly, yes, the officer testified that him explaining the form to the defendant should have been on his body-worn camera, but it isn't. But I think that's easily explained because the body-worn camera, the video doesn't begin until well after the interaction's already begun. The defendant's already in the store, handcuffed, and yes, the trespass notice was already filled out. We see that clearly in the video. So certainly, the testimony was that the explanations were given at the time the trespass notice was filled out, so it would be make perfect sense that it would not be on the video. The explanations wouldn't be on the body-worn camera because it was already filled out prior to the video beginning. And if there are no further questions,
One last question. The defendant also had priors with respect to this type of encounter. Am I right?
correct. Yes, he'd previously been convicted for third-degree burglary, and it came out in cross-examination that, to some extent, he was aware that he was convicted of burglary in that instance because he signed a trespass notice in that prior event. So I think that was also something the jury heard, and just one more reason why they discredited his claims that he was never.
I think that was July 2019. He had signed the trespass notice, right? That was, I think the prior trespass notice was July 2019.
July 2019 was this case. I'm not sure when the prior notice was signed, but it was a previous conviction that he was convicted of third-degree burglary and where he had signed a trespass notice in that case.
Thank you.
Thank you.
I would just like to address the body-worn camera footage again, and again reiterate to a question that was asked that this form is seen on camera, but we don't see anyone introducing this form to him. No one shows this form to him, even though we see it being passed back and forth between the officer and the clerk. And at the heart of it is that we don't know. There's so much doubt here. I mean, there's, as I mentioned, so much footage here, and none of it memorializes this idea that this form was introduced to him. And I do want to push back and say that the body-worn camera footage does show some signs of mental illness. I mean, even in this, within the officer's body-worn camera footage, we see Mr. White is speaking about things that aren't really relevant to the situation. And so we do see so many different signs of mental illness, and it does play a role here.
I'm sorry, before your red light goes on, in order to reverse on weight of the evidence review here, would we have to discredit the testimony of the police officer and the store employee and credit the defendant's testimony?
So I ask that you do discredit the officer's testimony and to look at the totality of the circumstances here and to look at the facts here and all the contradictions that we see within the evidence. Again, the specific facts in this case really show that there was just not enough knowledge, there was not enough information provided to Mr. White that would have made him properly aware, and all of these things together is what makes the difference here. And so looking, yes, at the officer's testimony, seeing how that is contradicted by the video evidence. The clerk herself had mentioned that she didn't believe anyone had read him the form. She had said that she couldn't understand if Mr. White had understood the notice. And so again, looking just at the specific facts and just to reiterate the fact.
Any significance to the fact that there was a prior incident where he had in fact signed a trespass notice?
I think that the important thing here is to look at this notice. I believe that any previous notice, I'm not sure exactly.
Well, I think he admitted to that, right, in his testimony? Is that? I thought that during his testimony he mentioned that.
I don't.
But anyhow, but it was before the jury, so any significance to that?
I think that, again, looking at everything that happened here, all of these convictions, they stem from this one date, from this July 2019 date and this trespass notice. This was the time, even though the store clerk had said that she had seen Mr. White.
I'm sorry, all his convictions, you're not talking about his prior convictions?
No, just the convictions under this indictment. He, again, was, the store clerk had testified that she was aware of Mr. White, but no one had ever told him previously that no one had ever told him that he could not return. Really at issue is this July 2019 date and this trespass notice that was filled out, and whether that was, whether Mr. White was adequately informed about this to the extent that he knew that if he would return, he would be facing such a serious felony offense such as burglary, and the fact here is that he wasn't. Through all the circumstances here, all of the facts put together, we see that there's just not enough. There should have been more here to make sure that Mr. White was aware.
Thank you. Thank you both.
Thank you.
2512 7th Avenue.
Good afternoon, Your Honors. May it please the court. Christopher D. Scozen for Appellant Webb and Brooker, Inc. Respondent claims that Webb and Brooker is liable for breach of contract, but there was no breach here. Rather, there was a series of email exchanges in which the respondent agreed to a mutual termination under the agreement. Paragraph 27B of the contract between
Given that this is a pleading motion, do you think that email response, which was simply thank you, right? That was all it said? Is that enough to show?
The first one, Your Honor, actually respondent said okay, and then asked for 2 extra months.
Right.
And so then the second one was a confirmation.
Thank you was a confirmation?
Well, it was in essence, the second email was they had provided 3 months notice, waived all their fees and said, we're going to terminate the contract by such and such date. The respondent asked for, said, okay, but would you agree to 2 more months?
How does that show an unequivocal consent to the termination? Thank you.
Well, it's a meeting of the minds, Your Honor. They did not counteroffer. They asked for, they said okay, and then they agreed. They asked for a couple extra months. So therefore, when a month later or a month and a half later, when the appellant asked for, reminded them that this is the termination date, they acknowledged that. So there was a meeting of the minds there. The respondent had agreed to the mutual termination, and the mutual termination was permissible under the contract. So when
How are these facts different than what the Court of Appeals considered in Orthon?
I'm sorry,
In 2024, I don't know if I'm pronouncing it correctly, in Orthon, it seems that the Court of Appeals considered this very issue, right? Where there's a request to terminate, then someone continues to perform, and are you familiar with that?
Is it cited in my papers, Your Honor? My hearing is a little bit off.
Authum LLC v. Nick and Duke LLC. It's a Court of Appeals case from April 2024.
I didn't cite it in my papers, Your Honor, but I don't.
Well, we're not limited to cases cited by parties in their briefs. We kind of look to the Court of Appeals sometimes as well.
I'm sorry.
It's a pretty significant case because it kind of mirrors these exact same facts here. And
Right.
the Court of Appeals did not go along with your argument, and I know this because I was on the other side of it on the 81 case. So I'm just wondering, but since you're not familiar, it's fine.
Right, and my colleague mentioned in terms of the pleading stage, and that case dealt specifically with issues on the pleading stage, at the pleading stage.
Right, Your Honor. Well, I would request additional briefing if that's possible, to the extent that we could address that case in the argument. But
Well, counsel, looking at it, the plaintiff never wanted the defendant to pull out. Is that? I mean, if you look at the April 21st, 2022 doc, the plaintiff said, I don't accept this consent. I don't consent to the termination. You see an attempt to, can you at least stay until this date? Because we can't get someone else to fill the management position at this location. And then there's an email that says, we already reallocated our people to other projects, which was interesting. May 13th, unfortunately, we have already reallocated our staff to new projects and will not be able to extend the date. HPD will allow you to self-manage for a few months in the interim, and this all with an expiration date for the contract of August 31st. So how can you argue that there was no anticipatory repudiation?
Right, Your Honor. Well, that letter was after the agreement already, so they had already gone through the process of giving notice. There was acknowledgement on the part of the respondent, and then they reconfirmed it later, and they didn't object. They said thank you. And then at that point in time, the appellant basically relied on the representations of the respondent and reallocated its services to other clients. So therefore, after they had already entered into the agreement, only then did they try to rescind it later, but it was too late.
Thank you.
Thank you.
Your Honors, good afternoon. May it please the court. My name is Gregory Reed, and I appear for the respondent 2512. As the court so aptly noted, there has been no agreement. There was only a series of 2 exchanges. One was the November 21st, 2021 letter in which the appellant declared that they were terminating the agreement. There's no offer. We are ending the agreement effective February 28th. There's no negotiation. There's no offer. And my client merely said, do we need more time? That is not an agreement. That is not.
It's not a meeting of the minds?
Not at all.
Thank you. It's not a meeting of the minds?
No, Your Honor, there's no meaning in the mind. And clearly, saying thank you does not mean I agree. There's no case that the appellant cited in which the court held that merely saying thank you means that we agree. Thank you is a mere expression of gratitude. It is not an expression of assent. The court.
Or thank you for staying on those extra 2 months. Now the relationship is terminated.
Thank you for sending the email. And it wasn't even, the email didn't even come from Mr. Menon. It was from some undetermined source.
Bottom line, it wasn't an unequivocal consent. It wasn't unequivocal in that thank you could mean many different things.
Exactly. It's a very ambiguous statement. Otherwise, the city would have many contracts based on thank you. It just is not a sufficient basis to form a contract as justice not held below, especially at this pleading stage. It is not an ambiguous, it is not a refutation of the plaintiff's evidence at all.
What is it that you want out of this litigation? Have you been damaged? What exactly?
Well, we've been damaged because, first of all, we discovered violations that the appellant committed, and we just felt that the appellant, and we were trying to convert to a co-op. It just totally disrupted our entire plans, and we have been damaged correctly.
Go ahead.
The agreement allows for a party to unilaterally leave if they give 60 days notice prior to the termination date of the agreement. Otherwise, it'll continue.
Yes, it rolled over, correct.
So at the time they sent you the letter where they said we're giving up, that was the November 17th letter. Then it was August 31st, August 30th, 2021 that they could have.
Yes, they could have waited till then, but they said February
60
28th.
days prior to that. Yeah.
Exactly.
Okay.
Exactly. They did not follow that unspecified termination procedure.
And it wasn't a notice as in we're going to be leaving you at the end of the lease term, right?
No, we're leaving
more
February
like we're pulling
28th.
out now.
Exactly. Yeah. Exactly. And that is a breach of contract as the court. That is a anticipatory repudiation of the contract as all the cases hold. There's no dispute about that. Thank you.
Thank you.
Counsel, are you aware of any case where a contract has been ratified by saying thank you? Because that was
I
kind
think
of
that
a
we need to look at the earlier exchange.
No. Case law. Are you aware of any case that or anything that says thank you is enough?
Not exactly the words "thank you," Your Honor, but
I mean, yes is unequivocal, right? But thank you is polite.
Well, you're reading thank you. You're reading that email in conjunction with the prior email, right? And you're saying that the two together.
I also, yes, Your Honor, and the thank you was in response to a reminder that the contract was terminated. So he didn't object. He said thank you in the sense that, okay, understood. So I would argue that in conjunction with the earlier agreement was a meeting of the minds that this agreement was going to end.
Yeah, but the earlier agreement was still sort of contingent. It was more like a negotiation, it seems to me, than an agreement. Because they said, can you stay on longer? Can you stay on until August 1st, I think they said. So that's not, that's a continuation of a negotiation. It's not an agreement. Tell me why I'm wrong.
Because they agreed to because they asked for 2 extra months and they agreed to it. So the respondent said, can you stay on 2 extra months? And the appellant stayed on the 2 extra months, continued, and then did another 3 weeks.
So you said that we brought to your attention the Court of Appeals case. In your brief, which you actually cited MCAT Robeson Apartments. But that case, there was a specific statement that the agreement could be terminated at defendant's discretion with certain conditions. Here, we have the agreement states that it can be terminated, could not be terminated unilaterally at one party's discretion.
Right, but it provided for a mutual termination, which was mutual in writing, which is what happened here. They gave notice, they consented, they agreed to the extra time, and then they reminded them, okay, like, we've given you now 5 to 6 months notice, but you've agreed to this date, and we are leaving. And they said, thank you. They didn't object and say, well, now here we want more time. And I would sort of stress the fact that the respondent, I mean, the appellant had worked for 10 years for this client, and the notice of termination was extremely polite, basically saying, with heavy hearts, we are trying to like work with you on this building, but it's become impossible and it's destroying our business. So we're going to waive our fees for 3 months, and we're going to, and then if you haven't, sort of fixed things or whatever, then we're going to, that's the termination of the agreement. They responded by saying, okay, but can you give us an extra 2 months? So then they gave them 2 months plus and reminded them that, okay, the agreement's ending at this point in time. They did not object. They said, thank you. So I would state that that's a meeting of the minds. And, it's in our paper that they should be precluded from arguing a breach of contract where my client relied on these representations and reallocated his services after this 6-month period where basically respondent let them believe that the contract was ended.
Thank you. Thank you both.
Thank you, Your Honors.
Dov Kip, New York.
Good afternoon, Stephen Bergstein for the plaintiff appellant. This court should reverse and find that the plaintiff is entitled to proceed as a Jane Doe plaintiff. There really is no reason to require the plaintiff to litigate under her actual name.
Let me ask you this question, counsel, because I saw that the plaintiff's affidavit was not submitted until the reply papers.
Correct.
Initially, did the plaintiff meet her burden other than submitted it in the reply papers?
Well, she certainly met her burden when she submitted the affidavit in her reply papers. There are cases, we cited cases that allowed anonymity even without the plaintiff's affidavit. That's the Yeshiva case. But more importantly, the Supreme Court did not abuse its discretion in considering the affidavit, and it took it into account in deciding the motion. And there are cases that say that if defendant is prejudiced by the belated affidavit, they can always submit a surreply. But the point is, we have the plaintiff's side of the story in the record, and there are no contrary affidavits by any of the defendants that would show any prejudice or any factual arguments that would counsel against anonymity. All of the factors that are relevant to anonymity in these cases apply to the plaintiff's case. This case involves behavior of the, quote, utmost intimacy. It's a private and personal video that she did not circulate and never intended to have circulated. She's most likely a crime victim. Somebody circulated this without her knowledge.
Does the location of where the intimate acts occur have any materiality here? I mean, if we were talking about a case where there were intimate acts that someone engaged in their own residence or abode, that isn't this case, to what extent is that material?
Well, if it's at home, it's even more private. It's probably the most private place in the world. But I don't think there's any dispute that this was private video, that no one intended to have publicized, except somebody did it, and she's probably a crime victim. And another factor is whether she would suffer significant emotional injury. She would. Without anonymity, it's in her affidavit. That's not really disputed.
No, the issue, I think what my colleague was kind of getting at is the location where this occurred. Does that somehow lend it to some type of public entity, therefore making it more, therefore there should be, she should not be able to proceed anonymously?
I seriously doubt it because it was revealed in a school, but not by anything she did. Somebody did it, but she didn't do it. It circulated at school. Her students saw it. Everybody saw it. But the fact that it circulated at school, I don't think that's one of the factors in determining whether the plaintiff can proceed anonymously, especially considering the circumstances in which this video was circulated.
Well, the Supreme Court found that the school, because it was publicly funded, was a public entity. And that was significant because a challenge to governmental policy ordinarily implicates a public interest.
It's a charter school, so
Yes.
it's a gray area. We cite
Well,
cases that,
charter schools are publicly funded, right?
but they're operated by a board of trustees.
Right, but they're normally in a public school. I mean, yeah, it's debatable, yes, but assuming that it is a public entity, why would you not, therefore, there be a basis for her not to proceed anonymously?
Even if it happened in a public school, I don't know why she would have to litigate this under her name. How would that factor into?
As a public entity.
Yeah, but the balance of the equities, you have all the other factors that would counsel in favor of anonymity. You know, she's a victim here. She's an innocent victim. There's no evidence to the contrary. And so, you know, the fact that it's a private school, not 100% public, I think it's even more humiliating that it happened in an arguably public setting because so many people saw it, and you saw the affidavit. She's so humiliated, she was suicidal, and you know, she wrote that if she knew she would have to use her name, she might not even have proceeded with the lawsuit. There's no prejudice to defendants in this case, zero, and there's no evidence that shows prejudice, so it's not disputed. They know who she is. They have her name. They never submitted affidavits showing any prejudice. And where's the public interest?
Well, the plaintiff's affidavit wasn't submitted until reply. Did they have an opportunity to submit something to then show prejudice?
They could have submitted a surreply. There are cases that say that. In this context,
Ask for permission to submit a surreply.
they did not ask permission to submit a surreply, but they could have, in opposition to the initial papers, they still could have submitted affidavits and said, even without her affidavit, here's why we have to litigate this case under her name. But the cases in these situations, in an anonymity cases, say, if you have a chance to submit a surreply, then you should do it, and they never did it.
Thank you.
Thank you.
Good afternoon, Your Honors. I'm Judy Shaughnessy from Wilson-Elser for the school and the individual defendants. Respectfully, Your Honor, I do believe that the plaintiff's affidavit was not only late, but was insufficient to overcome the public interest in having open court records with respect to these public school children. And as much as we...
With respect to the factors that we have to apply, would you concede at least that your clients were not prejudiced by allowing her to go anonymously?
That is correct, Your Honor. I do think that allowing her to proceed under a pseudonym places additional litigation burdens and things of that nature, but in the strict sense of my defendants continually being able to defend a suit, that much absolutely I concede is correct. On the other hand,
So, counsel, I'm looking at the I don't know how to pronounce it, Conducor elements, challenge to governmental activity or individuals. You're saying that there's a governmental activity here, or a governmental interest because this is a charter school, but I'm looking at the other factors as well, whether disclosure is of information of the utmost intimacy. That would probably be a check. Whether the disclosure would put the person, the plaintiff, at risk of substantial physical or mental injury. I would imagine everybody would agree that's a check. I can't imagine disclosure of a person's name in conjunction with this video would cause anything but distress. And then you go to whether the defendant would be prejudiced and whether the public interest in guaranteeing open access to proceedings is implicated. How do you end up here? I mean, what is the benefit of publicizing her name other than to punish her further for the disclosure of a video that was supposed to be private?
Your Honor, punishment is certainly not the goal. The existence of the video is not the issue. The way that the video got distributed, as much as she may be a victim, there are public school children to whom this video got out.
Let's talk
because it
about
was
that,
not-
because you say that in your brief, that any failure of the employee to sufficiently secure measures despite being aware of the environment in which she works and the potential harm that can result through an inadvertent disclosure is evidence of a lack of judgment. That is a legitimate concern when it comes to a school teacher. It is not slut shaming, right? So that's from your own words.
That is true, and I stand by that, Your Honor. I do think the Lerner case controls here. Because, yes, of course, it is humiliating to have video like that out there, but that is simply not sufficient.
But if it wasn't on her phone, it wasn't on her laptops, was it?
I don't know, because she doesn't say that you couldn't access it off of her phone. There is 2 lines in her affidavit.
She turned over her devices. Is that an issue?
I don't know, Your Honor, there is nothing in this record that says that, because the complaint is not verified. Not only is it not verified by her, it is not even verified by her counsel. It's an unverified complaint, which of course they can do, but then you don't get to rely on it as evidence, as proof. The only factual statement as to the circumstances of how this got out is a very carefully worded 2 lines on page 89 of the record where she says, I didn't mean for it to get out, which I certainly believe is true. But under Lerner, her embarrassment as a result of what happened is simply not sufficient to tip the scales.
Isn't it more than embarrassment? I mean, counsel made reference to the affidavit. The affidavit, which admittedly was submitted in reply, says, I'm willing to disclose my therapy records to show what emotional distress
Again,
I have suffered.
if I may, Your Honor.
Please.
Respectfully, that's not what it says. It doesn't have an affidavit from her therapist that says, I can substantiate it. It has her hearsay saying my therapist could, but by the way, I'm not going to do that now.
Paragraph 8, my therapist can testify to and/or confirm all of these symptoms.
She's in no position to say what the therapist could have, she
You're
could have
contradicting
submitted.
yourself, counsel. You just
sorry,
said
Your Honor?
that you're contradicting yourself.
I'm not. I'm saying that she did not submit an affidavit or an affirmation from her therapist that says, I know this to be true. She's saying, I said this to somebody else, and they can tell you that I did, which is not the same as saying on
Counsel, can
personal
we just
knowledge.
refocus for a little while, for a moment? You conceded that there's no prejudice. What is the public interest, or what would be the public interest in disclosing her name?
Your Honor, I believe that the balancing requires outweighing the public interest in both generally speaking, records being public, and in this case, the fact that you have.
So why would the public, why is there a need for the public to know about this incident?
Again, general public interest in open records, and in addition, you have New York public school children to whom this video was disseminated with the same level of carelessness that you saw in Lerner. Lerner involved.
But again, she did not disseminate the video. Someone else did.
There is no way to know that on this record, Your Honor. She has utterly failed to establish that. She has 2 lines in her affidavit, very carefully worded only to say, I didn't mean to do it, and places the burden.
So wasn't this an airdrop?
The best that I can tell, the video was accessible on her phone without adding further passwords. In other words, it was not password protected. So anybody.
That's not how. I mean, I don't mean to go tech because we're going to go towards the record, but you know that that's not how airdrop works. You don't just walk by somebody and it goes over to somebody else.
Or somebody would have to have initiated the transfer, but I'm saying they did that. if it was on her, if it was through her phone, not physically stored on her phone, but through her phone on any cloud, without the need to further manually input a password, that could have been done.
But she did state that she could not find it on any of her own devices.
She did not state that it was none in none
Unable
of her
to
clouds.
locate the video on her work or personal cell phones, her laptop, Google Photos, Google, yeah.
Right, and I'm
Google
talking,
Photos.
and I'm talking about any number of cloud storage systems that exist.
But at this point in the litigation, why not proceed anonymously, and then later on, after discovery, et cetera, these issues would be fleshed out?
Your Honor, all I'm saying is she failed to meet her burden to do so at this stage.
Thank you.
Thank you, Your Honors.
A huge part of defendant's brief is basically blaming the plaintiff for this and suggesting it was her fault because somehow she was careless with her phone. There's zero evidence of this, and the complaint says on page 19 in 4 or 5 paragraphs that they couldn't find the video anywhere on her phones. It was not a school-issued phone, by the way. The Supreme Court.
I thought that the argument was that we don't know, that the record is unclear as to whether she herself disseminated the video or whether someone else disseminated the video.
The complaint says someone else disseminated the video because she didn't do it and nobody could figure out where it came from, so they thought maybe it was an ex-boyfriend who worked there. This is probably, what's the word they use for?
Revenge porn.
Revenge porn, because...
But I guess your friend's response to that would be the complaint's unverified and therefore it's not the equivalent of an affidavit under CPLR 105U.
But the complaint is written in good faith. You assume
But it's not
that.
verified, and I guess in her affidavit, she doesn't make reference to the airdrop,
I
right?
did not willingly disseminate any intimate video of myself or allow any student access to such video. That's in her affidavit, so we take that as true. She's a victim here. Why are they so desperate to have her name on this case? There's no prejudice to them. They can litigate this case as if, like any other case, there's no reason to do this. This
So
is
your adversary says that there's public interest because this is a charter school.
How is the public interested?
No, don't ask me.
Okay, well, the public, I'll answer. The public has zero interest in knowing.
Well, that's why we were discussing whether a charter school is in fact a public school or not a public school, or...
Quasi, but there's reasons to say it's not quite the same as...
Well, I think your friend was also arguing that school children, I don't know, have a right to know who this individual is, and maybe their parents, guardians, and caregivers also have a right to know?
That is a stretch.
Well, as a father of 2 elementary school children, I don't know how much of a stretch it is to want to know what's going on in schools, particularly if we're talking about younger children. Now, again, whether it should be done anonymously or not, whether there's knowledge of an incident of this nature and then there's knowledge of the individuals, the specific individuals, that's a different.
But it sounds like everybody at the school knew whose video it was because it circulated all over the place. So the only people who don't know is everybody outside the school. And what interest do they have in knowing her name? That's the problem.
Well, she's no longer at the school.
Correct, but then it's going to follow her for as long as she works.
So am I correct in stating that at some point in the future, it would no longer be anonymous after discovery, et cetera?
That's an interesting question. I suppose if somehow in discovery they can prove the elements are all in their favor, maybe they can force her to reveal her name. But for now, there's no reason to.
Yeah, thank you.
Thank you.
Thank you both. Jab Building versus 953rd Avenue. Whenever you're ready.
Good afternoon, and may it please the court. Paul Sasso from Feaster and Sasso on behalf of the appellant Jab Building, LLC. The order should be reversed because the documentary evidence in question, an email sent by respondent in October 2021, is at best susceptible to more than one interpretation. And the fact that there isn't an alternative interpretation to the one that the order chose mandates that dismissal.
Even if that's the case, isn't revocation possible? And isn't that what happened here?
The Supreme Court did not reach that issue. Instead, the only issue...
It was in front of Supreme Court, though. I believe it was argued below.
It was argued before the Supreme Court, but as the respondent also concedes in the appellate briefing here as well, the Supreme Court did not reach that issue.
We can affirm on an alternative ground that was raised before the trial court.
No, because this was not addressed by the Supreme Court. It has not been decided, and therefore it is. And we have cited this in our papers. It is
Dept and parochial school bus from the Court of Appeals, I believe, tell us that we can affirm in a civil case on any ground that was raised before the trial court.
I will consult our own brief and provide you with the citations that we provided there. But no, we believe that it was undecided by the Supreme Court and must be. It's not ripe for this court, nor would it have been ripe for the Supreme Court to decide, because the issue of retraction or withdrawal of a waiver is another fact question.
So here's the interesting part that I see at any rate. So you have an email in October that says we would like to terminate early, right? We don't want to have the air rights anymore, right?
Yes.
Okay. And it says, please let us know if you agree with this proposal. And the landlord replies, how, or the owner of the rights, how will the air rights be returned? Which is an extremely interesting question. After you build a tall building, how do you return the air, right? And then there's another correspondence. We can't return air rights because they don't exist anymore. We can give you a payment for one time. Let us know if this works for you. And there's nothing that in response. Instead, an action is commenced. An action is commenced by the landlord, and the other side says, okay, we're renewing our lease. You never agreed to it. You didn't agree to terminate our lease of the air rights, so we're going to renew it. What, like as my colleague said, what's wrong with that?
With respect, you skip a very critical point there.
Which one?
I'm sorry?
Which one?
You skip the fact that the respondent also, in response to receiving that complaint, admitted that they would not renew the air right, that they would not renew the air rights lease, that there was a justiciable controversy, and asserted a counterclaim in which they said, we are entitled to keep these air rights without paying you anything further. The idea that in October 2021...
That was very bold, wasn't it?
It was very bold, and it's completely contrary to the concept that they are now, and the order adopts, which is the idea that we never intended to tell you that we were not going to renew if, when the lawsuit begins, they actually lean in and they say, no, we plan on keeping these air rights, and we are not going to pay you anything, and they maintain that position for 2 years.
But then going back to Justice Moulton's point or question, so now let's see that they see the light after 2 years, and now they say, you know what, we'll renew. Why wasn't that plainly a valid revocation of a putative waiver?
If we had made it to that issue at the Supreme Court, it is a factual question that cannot be decided on a motion to dismiss. It does raise issues about reliance and prejudice, which were not litigated before the Supreme Court. There is no record as to what our client did in reliance on the statements that they were going to waive in the 2 years of litigating the issue.
So I'm sorry, sir, if I'm understanding you correctly, are you saying that they didn't raise the issue of the revocation of the waiver before the trial court? Or are you saying they raised it, but the trial judge didn't determine that issue?
The latter. The Supreme Court did not determine that issue, and we believe appropriately, because there's no way that they could have the Supreme Court couldn't have decided that issue, because it is a fact question. The fact question would then raise whether or not there was any reliance or prejudice, and there is no record. This was on a motion to dismiss, and in fact, so we did not put forward any evidence of reliance or prejudice, nor would we have been allowed to, because it was a motion to dismiss and it should have been decided on the pleadings alone.
Thank you.
Good afternoon, Your Honors. Paul Sweeney from Sir Tillman Ballin on behalf of the defendant respondents. I just want to take a step back here, because the action was filed for declaratory relief, unjust enrichment, conversion, based on declaring the rights if 2 years later, when the renewal option was ripe, it was not renewed, and what are the parties' rights then? 6 months before that right would have had the deadline, 6 months, January 24 before July 24, we notify them through the provisions of the lease that we have changed position, that we are going to renew. There's no dispute here. There is no justiciable controversy. The whole controversy was resolved when we notified them timely, 6 months in advance, that we intend to renew. The court below was right on its finding that the emails in and of themselves, language that they use, could not constitute a waiver.
So counsel, isn't the owner saying effectively, however, you can't yank my chain anytime you like? You know, here, now you see it, now you don't.
I think that is what they're saying, and the case law doesn't support that argument. We cited cases in our brief. Change of circumstances on a declaratory judgment action, the court dismisses the claim. There is no longer a justiciable controversy. It's the Brown case that we cited in our brief is a great example. So yes, that is their argument, but it doesn't have any basis in the case law. And I think if you go back and look at the wording of the emails that you were talking about, the two emails, again, 2 to 3 years before we had to exercise our right to renew, they're making proposals. Let me know if this proposal works for you. Let me know if you agree with this. Those cannot, as a matter of law, be an unmistakable, voluntary, intentional waiver of a contractual right.
That's maybe an invitation. Their argument, of course, is that it's an invitation to negotiate concerning the payout. But then there's the sentence in your email, your client's email, a further extension of the contractual relationship or an exhaustion of the extension options to which we are entitled are out of the question for us. So that's unequivocal.
That statement in and of itself, but if you read the entire email where it says, let me know if you agree with this proposal, and that's what the second email also says, let me know if you will agree to this, is clearly having a negotiation. It is not.
The second email, I think, is even more harmful to your position, though, because that's where Ms. Altholt says, it's not possible to reverse the transfer of air rights, therefore there will be no return. That sounds
well. That's the question here was whether or not the client was going to renew and pay rent for the next 25 years. If it didn't, then the question became, do they have to lop off the top floors of its building, or do they not? That's a separate question.
We're going to be litigating about this for the next 20 years.
But that is a separate question, Your Honor. And so I don't think the judge got it right that the language in those emails, and also they were not sent pursuant to the lease provisions. There's a merger clause in the lease. These are not amendments. They were not sent through the notice provisions, certified mail. There was an email exchange. These are not a waiver. However,
I think Article 15, you're talking about Article 15. I don't think that really helps you here because, I mean, this is not about notices, demands, and requests required or given hereunder. This is totally, the emails concern something totally different. So how do they qualify for Article 15?
The notice would be whether or not they're going to renew. And they're saying, you're saying an intentional waiver of this contractual right. You've given us notice you are not renew. When we renewed, we know how to renew. We sent it through certified mail as it's required of the lease. The same should be required of their claim that we waived the right to renew. But I would go back to the, I'm sorry.
Even if the emails could be construed as a waiver of its right to renew, you withdrew it.
And it's absolutely
It's withdrawn, right?
Absolutely revocable. And Your Honors, that was argued to the court below. And if you read the decision, the reason why you're not allowed to revoke a waiver, if you find that there is a waiver or a question of fact on waiver, is that the other side has been prejudiced.
Right.
They've been materially altered their position. The judge addressed prejudice in the implied waiver aspect of the motion. He said, you can't argue that you were prejudiced. You filed a lawsuit 2 years in advance. 2 years before their right to renew came up. You can't say I'm prejudiced, and they argued this. They had the ability to argue what their prejudice was. They said our prejudice is attorney's fees. That's not enough for prejudice. They decided on their own to file a lawsuit 2 years in advance.
Your friend put me in a position where I may get egg on my face, so I better get your take on this. Are you procedurally barred from raising or pursuing before us the revocation of waiver argument?
No, it was fully presented to the court below. Fully presented. The judge below
But not
stopped at
decided.
waiver, stopped at there, as a matter of law, there was no waiver.
Right.
He didn't reach in his decision the second prong
It
of
was
it.
presented but not decided.
Absolutely. And I think the important point is the same legal aspect of that argument and the reason why revocation was permissible, the judge addressed in the prejudice section of his implied waiver discussion and said there is no prejudice here.
Right, he said that they failed to present any evidence of any prejudice suffered by that.
Absolutely, Your Honor.
Thank you.
Thank you.
It is the only way that the order should be affirmed is if this court believes that the Supreme Court was correct, that out of the question could not possibly mean, under any circumstances, no, we will not renew the lease. We do not deny that there was a proposal in those emails, but the proposal related to prepayment of rent. And if the emails can be read as both a proposal concerning prepayment of rent and an affirmative and emphatic declaration that renewing the lease is out of the question, then at this stage of the litigation, if there's a second interpretation, the documentary evidence does not utterly refute JAB's factual allegations.
It could be both. We waive, but hey, we're willing to consider X.
That's right. What they were saying was, it is 2021. We would like to pay you through 2025. Will you accept that? Because there are issues about the negative interest rate in the Eurozone. But we are definitely, under no circumstances, are we going to renew this lease. It is out of the question.
So, counsel, since the lease wasn't even close to the end of its term, wasn't the decision to commence a suit 2 years early a little precipitous?
One might think that, but for the fact that the respondent did the exact same thing and asserted a counterclaim seeking the exact opposite and saying we are entitled to keep the air rights. It's not as if, and what we have said is that if they had truly never waived, what they would have done when they received the complaint is they would have said, why did you sue us? We didn't waive. We are still considering it. We still have 2 more years. Instead, they said, no, we are keeping those air rights and we're not paying you. And just to turn for a moment, because I do want to get back to the issue about prejudice and reliance, because even though I do not believe that is before this court, the issue that I want to make clear is that we did not, as my friend argued, say that our attorney's fees were the one and only form of reliance. There is no record on reliance. What happened below is that the respondent argued that our only form of reliance was attorney's fees. And because, again, we could not go outside the pleadings, what we said was, we cannot provide you a full record now, but the attorney's fees are enough. That what you have done is that you have forced us to litigate and spend 6 figures of attorney's fees, and that would be enough for reliance if that were our only form of reliance.
Thank you.
Thank you, Your Honor.
Where v. where? Yes.
Good afternoon, Your Honors, and may it please the Court. Aaron Zucker of Abrams Fensterman on behalf of Appellant Pam Thorwir. I'll start with the re-argument issue. Justice Chesler's underlying order was pretty straightforward. Justice Chesler held 2 important things here. First, Justice Chesler held that under the party's judgment of divorce, the husband was obligated to do 2 things: execute the deed to transfer title of the property to the former wife, and 2, also execute all ancillary documents necessary to effectuate that transfer. The court, Justice Chesler then held the second important thing. He said that the former wife is entitled to all damages stemming from the husband's delay or failure to execute those documents. That's it. That's Justice Chesler's order. Then Justice Hoffman, apparently misunderstanding the basis for the damages award in Justice Chesler's order, went in a completely different direction.
Can a judge do that if the judge is not an appellate judge?
No, Your Honor, and especially when it's not, it gets the whole, if anything, it's Justice Hoffman that committed a misapprehended a fact here. It was Justice Hoffman said that the basis for the award was the wife's refusal to just pay the transfer taxes. Justice Hoffman believed that if the wife
She
had...
couldn't do that until the paperwork was signed. You make that point in your brief.
Exactly, Your Honor.
Was the tax issue ever resolved? The purported tax issue that the husband brought up?
Well, the tax issue in Justice Chesler's order said that the parties would split the tax, the transfer taxes. if that's
Transfer
what you-
tax. And that was the sole tax issue that remained that the husband had raised?
Yes.
Okay.
And so basically that's the gist of it, Your Honors, unless there are any questions, any more
Any
questions.
educational expenses? Was there anything in terms of the educational expenses?
Yes, so that's the next point, Your Honor. The educational expenses, I mean, the party's judgment of divorce says that the husband will pay his 93% share of the educational expenses. The educational expenses, that term is not defined to be separated into categories.
Did anybody raise mandatory versus optional at the trial level before?
Not that I'm aware of, Your Honor. I'm not sure where this distinction came from. I don't think that the distinction has any basis in fact or law.
But the agreement just talks about educational expenses, does not talk about mandatory versus optional.
Correct, Your Honor. No split in what the term, and I understand that down the line, the term what constitutes an educational expense will have to be determined when certain expenses arise here and there. But this is different. What Justice Hoffman did was he split the term educational expenses in half to mean two different things. That's not what the party's judgment of divorce called for. It was bargained for. They didn't. That's just not what the judgment called for.
There are cases, however, that talk about what constitutes educational expenses.
I think so, Your Honor, and all of them speak broadly. One of the ones that we cite.
Well, that's the other thing. They all give a broad, I think they all state that there should be a broad interpretation of educational expenses. I think one talks about telephone calls.
That's what I was going to say, Your Honor.
Telephone calls are part of education, go under the category of educational expenses.
That was the case I was going to say, Your Honor. So unless there are any other questions, thank you.
Go ahead.
So here the divorce, sorry.
Justice Gonzalez has a question.
The divorce incorporated the stipulation, and the stipulation said that the basic child support would be paid at $75,000 instead of a higher amount. Was there a correlation between that basic amount and the agreement that the husband would pay 93%?
That I'm not sure, Your Honor.
Educational expenses.
I'm not sure of the.
May it please the court, Aminette Hassapidis appearing for the plaintiff in this case. The court properly granted the parties relief in part.
So how would Judge Hoffman of concurrent jurisdiction with Judge Chesler, how would he be able to basically overrule or modify the determinations by Judge Chesler?
Well, it's interesting you raised that, Your Honor, because counsel has said that, Judge Hoffman could not disagree with what Judge Chesler had said. However, Judge Chesler had disagreed with what Judge Cooper had said. On June 8th, 2021, when the parties first appeared, prior to the closing.
Two wrongs don't make a right.
No, Your Honor, but you're raising the issue. How could Judge Hoffman do that? Well, Judge Chesler did it as well. Judge Cooper had ruled at the initial appearance on the order to show cause that the judgment did not obligate my client to sign anything except the deed. It would be one thing if it simply said that my client had to transfer his right, title, and interest, period. What it said that
he signed the deed, though?
He did, and that's the thing. Everyone in this case, much ado has been made here about my client allegedly refusing to do anything. The problem here is my client was willing to sign a deed and was willing to sign the transfer tax documents, notwithstanding the fact that there was no mention of them in the judgment. He wanted his name off of this mortgage after more than 10 years, 11 years in this case. The problem was that the transfer documents that were presented to him and the deed were incorrect. I'd refer the court to the documents. Page 166, there's the 584 document purported to transfer the property for $1 of consideration and transferred 100% of it instead of 50% because they had owned it by tenants by the entirety to the defendant individually. That was wrong. Then the 5217 that was sent in June listed the full consideration but only included my client as the grantor when both parties were the grantors. Then, to add to that, the deed transferred 100% of the interest.
Hoffman, that's not what Judge Hoffman addressed, right? Judge Hoffman said that the wife could have mitigated her damages by simply paying off the transfer tax.
Yes, Your Honor, but I'm
and not incurred, like, I don't know, $100,000 in legal fees. I'm just taking that number out of my head.
right. But what Judge Hoffman pointed out was that the judgment did not obligate him to sign the documents. And my client had also pointed out that these documents were inconsistent. He would be committing tax fraud if he signed the documents. The 584 and the 5217 were completely inconsistent.
But the point is that Judge Hoffman stated that the wife was not entitled to seek damages for the husband's failure to pay the transfer taxes. You never raised that.
My client
never raised that, though.
That's right. My client never said, I shouldn't have to pay the transfer taxes. My client said, I'm willing to sign everything as long as it's correct.
Right. So the point is, Judge Hoffman ordered something or made a determination based on nothing. I mean, not based on any argument put forth by your client.
Well, Your Honor, that's a bit inaccurate because Judge Hoffman really took the laboring oar, went through the entire history of this case when it landed in his lap, and even reviewed the docket. So pages 6 to 13 of the record, you could see he went online and looked at what the history of the case was. And in his very lengthy decision, and I refer the court to page 19, he makes other findings. He says that crucially, there's no contractual obligation for the defendant, for the plaintiff.
But that brings me back to my first question is how does a judge of concurrent jurisdiction, how is he able to do so unless he finds that there's some type of, even if there's there has to be a glaring error, right?
But there was a glaring error. The documents that were presented to my client were patently inconsistent. He would have been committing fraud, and he is a licensed attorney. That was the sole basis for his hesitancy.
Excuse me,
I would point out.
Chesler address that or grapple with that issue on the underlying order, I'll call
Not
it?
at all. Judge Chesler did not address it all. We even point that out in the brief that Judge Chesler.
So how is it before Judge Hoffman for review? I mean, we keep going back to, I think you're hearing the word concurrent jurisdiction, right? Can a judge of concurrent jurisdiction overrule another judge?
On a motion to re-argue, yes, a judge
You're not
may. And that-
overruling.
Well,
Don't
not
concede that.
No, I'm
What
not
you're
overruling.
doing is the judge inherited this case.
Right, he inherited.
Now the question is, did Judge Hoffman exceed the scope of review he was permitted to undertake under re-argument?
Right.
No.
Not that he was he was giving, but did he do that or did he go a step beyond?
Fact or law? Fact or law that was overlooked or misapprehended?
Right.
That's the determination.
Okay, well, Judge Chesler said that under the judgment of divorce, and I believe it's page 46, my client under the judgment was obligated to execute all the transfer documents. Judge Hoffman at page 21 says, neither party argues that the judgment is ambiguous with respect to the obligation to pay the transfer tax. In fact, at page 106 of the record, the defense counsel conceded that the judgment was silent about whose obligation it was to pay the transfer tax.
So was that a misapprehension on the part, according to Judge Hoffman, was that a misapprehension?
Yes.
On the part of Judge Chesler?
Yes, and it was consistent with what Judge Cooper ruled early on. You have to remember, when my client filed opposition to their underlying motion, Judge Cooper had already held, this judgment says nothing about transfer taxes. He says I can't make him sign off on these documents. And at that same hearing, and I realize my time is up, but I'd like to just be heard a moment longer.
Oh, yeah, it's been up for a while.
Sorry, Your Honor. May I?
Yeah.
Okay. Judge Cooper said I can't obligate him to pay the transfer tax now. And all my client said was, I'm happy to sign these documents if they're correct. My client wanted this to be a taxable event. The defendant wanted this to be a zero consideration, no tax event. And my client was penalized even though Judge Cooper held that he was only obligated to execute a deed until January 26, 2023. How do you hold my client responsible for delayed damages when he was in full compliance with Judge Cooper's
What about the
PRO?
educational expenses? Where is there anything in the agreement that talks about, that makes a distinction between optional and mandatory.
There isn't, but Your Honor, my client, the court was faced with a dilemma. The plaintiff had argued that anything, this is a quote, anything that can reasonably fall within the scope of educational expenses is compensable. The plaintiff had argued that only tuition was compensable. The court held, well, looking at the other cases, I'm going to make this delineation for these parties. Again, we're at motion number 22 in a matrimonial action with a 2011 index number. The court was trying to provide clarity to reduce litigation here. The court also pointed out that a lot of the expenses, and again, we're only talking about $8,700 in the scheme of things. My client was ordered to pay over $105,000 of the $114,000 that was demanded by defendant. The court said, I can't tell what these expenses are. Something that you pay for at the bookstore is not necessarily an educational expense. She could have purchased clothing at the bookstore. So given the failure to delineate what a lot of these expenses are, and given that lockouts are an optional thing, there were other non-mandatory expenses, that was the ruling of the court.
Well, if you're locked out of the dorm, right?
Yes.
Lockout?
Right.
Okay, so how do you, like, if you're locked out of your dorm, what are you supposed to do?
Well, Your Honor.
Why is that not an educational expense?
Well, Your Honor.
Because you can't pursue your education, right, if you can't get into the dorm room.
Well, I understand that, Your Honor. At best, that's $1,000.
Thank you.
Your Honors, I just want to make
Could you address the issue as to the Judge Hoffman making a determination that Judge Chesler overlooked or misapprehended the issues as to the transfer documents?
So, Your Honor, Justice Hoffman, there were several prongs in the former husband's re-argument motion. One of them challenged Justice Chesler's directive that he had to sign all the transfer documents. Justice Hoffman's order on page 40 did not grant that portion of the re-argument motion, effectively upholding the portion of Justice Chesler's order that says you have to sign all of those transfer documents, which then brings me back to the whole point that I'm trying to make, where Justice Hoffman just completely misunderstood what the basis for Justice Chesler's damages order was. Justice Chesler said the failure to sign those documents, which the husband was required to do under the judgment of divorce, is what caused the damages to the wife.
What if they contained misrepresentations that the defendant or the plaintiff husband knew to be misrepresentations?
Your Honor, these arguments have been raised in motion after motion after motion. Justice Chesler's order was not appealed from by the former husband. That's where you could have made those arguments. It wasn't appealed from. And then the only other thing I want to say is that Justice Cooper, and we talk about this in our reply brief in response to this argument, did not say anything. And Justice Cooper's order was made in response to a motion for injunctive relief, and injunctive relief, any determination on injunctive relief is not law of the case. It doesn't have preclusive effect and wouldn't have any effect afterwards.
Thank you.
Thank you.
Joseph Free, New York City Department of Housing.
Good afternoon, Your Honors. May it please the Court. My name is Michael Bennett of Cooker, Marino, Winiarski, and Bittens, LLP. I'm here on behalf of both of the petitioners. And I would like to start by pointing out the larger context of this case. So if the Court would take judicial notice, something not included in our brief but is a public record, it's the Mayor's Managerial Report. It's issued every year, and prospectively for the year 2025, it states that for the fiscal years 22, 23, and 24, 99% of OATH's findings of facts and conclusions were upheld by the administrative agencies. So with that context in mind, I would like to further point out that it seems to the petitioners that HPD has, even if it can be said, and I think it is fairly said, that they do have a statutory right to reject a report and recommendation made by an oath judge, an AOJ. But I think they are far exceeding that statutory right and have put on the hat of judge, jury, executioner, and prosecutor, and throughout the course of their briefs
But counsel, the former owners failed to provide heat and hot water for extended periods. Isn't that game over at that point?
No, actually, I appreciate the question, Judge. I think that was one of the main points I wanted to hit on today. And the inquiry period, the relevant period here today, is 5 years before the submission of the application for the certification of no harassment. So our inquiry period begins in January 12th of 2018. Shortly before that, in July of 2017, there was an emergency order issued to shut down the boiler. Within 2 and 9 days after that event, the record reflects that on July 12th, which is 2 days after the boiler shut down, the architect's proposal was obtained to fix the problem. Within 9 days, on July 19th, 2017, there was a proposal for the scaffolding. Thereafter, as HPD would say, we finally filed a lawsuit to get access to the neighboring property to facilitate the repairs on the roof, including the parapet wall, the bricks, and then after that, the boiler system.
So your client purchased the property with knowledge that the building was enrolled by HPD in the Certificate of No Harassment pilot program.
Yes.
Therefore, your client would have had notice that there were problems, that this was a problem building. It wasn't merely a vacant building. It was a building with a history, and it was going to be scrutinized in a special way before any permits would be issued by the city in order to do an extensive renovation here. So I don't understand how the extensive history of the building as far as being in noncompliance with the codes, the relevant codes, that was ignored by your client?
No, it wasn't ignored. And if I recall correctly, I do believe that the contract for sale brings that up and specifically memorializes what Your Honor is saying. But with respect to the violations during the inquiry period from 2018 to 2023, which is about a year after they bought the building and 2 years after it became fully vacant, right? In 2018, the former owner, Ms. Sillen, who herself was nearly an octogenarian and in failing health, was able to clear 40 Class B and C violations.
But there were still several, maybe 24, outstanding at the time of the hearing.
Right, and then thereafter, 78 total Class C violations were closed by my client by the executor of Ms. Sillen's estate during the inquiry period. And the only violations from 2019 to 2022 were 14 for one unit, Unit 7, on September 26, 2019, and there was timely filed certifications of corrections on October 19th for 6 out of those 14.
And effective March 7th, 2024, there were open 12 Class B and 10 Class C violations still open 2.5 years after the purchase by your client.
Well, Judge, that would be 3 years after the building was fully vacated, and if there's nobody in the building, there's nobody to harass.
You're in the so what category?
No, I wouldn't say so what. I would just think as a purely logical matter, if there's nobody residing there, then there's nobody to harass. But just this turning back.
Some of those people who left, that vacated the building, as you said, that wouldn't be there for harassment, they in fact left because there was no heat, hot water, and other issues in the building.
May I respond to?
Please.
In response to your question, Your Honor, and I understand exactly what part of the record you're referring to, what I would say is that the investigator only spoke to 3 of the tenants who were in occupancy. To one of them moved to Germany, the other accepted a buyout, and the third, Ms. Olberding, was not spoken to until 9 days before trial.
But I thought somebody did state that one of the reasons they moved out was because of the lack of heat and hot water.
So that's a triple hearsay statement made a week, maybe at most 14 days before the trial started, a year after investigator Donaldson's initial investigation, highly suspect circumstance. This is exactly the reason why we have
How many tenants were in this building at the time that you took it over and you purchased it?
It was vacant.
Excuse me?
It was vacant, Judge.
It was vacant.
And so just to continue responding to the point about the
Yes,
former tenant,
you can certainly do so on rebuttal.
Yes, Your Honor.
Good afternoon, Your Honors. May it please the court, Philip Young here on behalf of the city HPD.
This court should confirm HPD's determination here in this transferred Article 78 proceeding. Substantial evidence supports HPD's determination, denying petitioner a certification of no harassment here.
But you just heard your adversary discuss the clearance, it's not clearance, how do you say, compliance, that there was compliance by the prior landlord to some extent before she died, and that there was subsequent compliance to some extent by the new owner. And this building should simply be given a permit to go forward with renovating a vacant building. What's the problem with that?
Your Honor, we don't dispute that the record shows that the former owner and the estate made some repairs and made some efforts to correct violations. But as Your Honor's noted, there were 22 open Class B and Class C hazardous and immediately hazardous violations that remained open during the inquiry period. They remained open when tenants were living in these units, and at least 2 of them were building-wide violations that were not specific to any unit. These are issues with lead paint. These are issues with defective fire escapes and fire egress issues. These are serious hazardous and immediately hazardous violations. And under the statute, that creates a presumption that the owner's actions intended to cause these tenants to vacate. And the mere fact that the owner happens to have corrected some other violations isn't sufficient to rebut the presumption of intent here when there is no evidence that this owner made any efforts, any good faith efforts to try and correct these 22 open violations during this inquiry period.
Could it raise eyebrows that the final determination of the HPD commissioner reflected a rejection of the ALJ's conclusions?
No, I don't think it should raise eyebrows at all, Your Honor. I mean, at the end of the day, both the statute and the regulations provide that this is a report and recommendation, and that HPD is free to accept or reject that report and recommendation within 45 days, which is what HPD did. They prepared an 18-page order describing in detail why they were rejecting portions of the ALJ's recommendations. And at the end of the day, this is a substantial evidence transferred Article 78 proceeding, and what this court is reviewing is HPD's determination, not the oath ALJ's recommendation. And I just want to emphasize here, there's other evidence of harassment aside from the violations, the heat and hot water that we've talked about. I mean, the clearest and most obvious one is statements from a former tenant, Laura Olberdine, saying that she left this building during the inquiry period because the building did not have heat and hot water for 7
Well,
to
your
8
friend
months.
states that that was hearsay.
So it is hearsay, Your Honor. Hearsay is admissible in oath.
Guys would be out of business if there wasn't hearsay.
Because that's where the investigator speaks to the individual.
That's correct, Your Honor. And it is not triple hearsay. It is at best one level of hearsay because the HPD investigator testified at this oath hearing and testified about his conversations with this tenant, Laura Olberdine, and described those to the ALJ.
And there was also a tenant who I believe refused to speak because of a non-disclosure, right? Who took a buyout? Was there one who was?
There were tenants for which that was the case. That was not the case with Laura Olberdine. She did not take a buyout.
No, not her. Wasn't there another tenant who stated that?
Yes. In HPD's investigative report, I think it's Exhibit 1, the investigator spoke with 1 or 2 people, I think, who said that they could not talk to the investigator because they had signed a non-disclosure agreement, entered into a buyout agreement of some sort.
So while it would be speculative as to why they actually left, whether they left because of the conditions in the building or because of some other reason, why they took the buyout.
Yeah, I mean, as to those tenants, certainly there's not direct evidence in the record that they left because of the conditions in the apartment. You certainly have that evidence with respect to one tenant, and then you have all of the other evidence of harassment that creates a presumption of intent under the statute.
Counsel, there's a term for the CONH designation, right? Excuse me, not the CO, the designation of ineligibility for a permit. For permits, has that expired? Is it still Are they still barred from getting permits?
Yes, so under the statute, I believe if you're denied a certificate of no harassment, you're barred from performing certain major renovation work for a period of 5 years. To be clear, under the statute, you are allowed to perform a lot of other work that is not quote unquote major renovation work where you're splitting up units and doing things like that. They can paint, they can change appliances and things like that.
Thank you.
Thank you, Your Honors.
So, Your Honors, in rebuttal, we cited case law in our brief that stands for the proposition that a report of an investigator with a hearsay statement of another person who's not present and not sworn to that by other person has little to no weight. Over objection, Judge ALJ Chirilli at the oath trial took the hearsay statement by the investigator into evidence with a reservation as to its weight. The notion that a hearsay statement obtained less than 2 weeks before trial, over a year after the original investigation, and that contradicts the only real evidence in the record, which is that her lease expired in April of the year in which she moved out. That's the evidence in the record.
We agree with you on that point.
Right.
That the hearsay evidence should not have been given any weight. What portion of the charges or claims before the administrative agency would have been fatally undermined? Were all of the various administrative charges against your client predicated on that hearsay?
No. Under the statute, which says that where a act of harassment causes somebody to move out the building, if you by petitioner's argument, then that the only evidence is that the lease expired the same month she moved out. Oh, and by the way, she had heat and hot water for 2 months before she moved out. Then in this case, the court could not find that the alleged acts of harassment caused that individual to move out. The rest of the issues would be dealt with under the standard of whether or not HPD met its burden of establishing the intent to harass, and whether or not at the oath trial, the presumption of intent to harassment was effectively rebutted, which we submit was done. And I just want to note again, for the record, I think it's critically important on the issue of whether or not, may I just finish this point? On the issue of whether or not the conditions in the building, particularly the boiler, caused Ms. Olberding to move out. Again, by the time, I'm sorry, 1 second. As of January 2018, when the inquiry period began, there was an order in place in the housing court that made my client unable to do any work. All of the work was assumed by HPD. HPD actually wrote language that the former owner was stayed from interfering in any fashion with the work that was done. So that even if the boiler condition caused Ms. Olberding to move out, which we contest and do not concede, the bottom line is that the ball was in HPD's court at that point in time.
So you're stating that in the record, it shows that during that 2-month period prior to her moving out, you were precluded from providing heat and hot water?
That's exactly right, Judge. No, we're not providing. Actually, I can clear that up for Your Honor.
From fixing the boiler to provide?
Yeah, from fixing the boiler to provide the hot water.
And that's in the record?
That's in the record. That is actually, that order was Exhibit 10. I'm sorry. That order, the order's in the record. It's dated December 20th, 2017. The inquiry began January 12th, 2018. So from that point on, the ball was in HPD's court. It was up to HPD to ameliorate the issue. Just because HPD took until February or March of 2018 to install a temporary boiler, and then until August of 2018 to permanently remediate the situation and file ministerial paperwork associated with that, doesn't mean my client caused harassment.
Thank you. Thank you both. Zurich American versus Providence Capital. Yes, proceed.
Thank you.
Yes, I know. I'm sorry. 4 minutes.
And I do want to apologize for that. It's the first time the New York subway system let me down for a calendar call. I was 5 minutes late, and I apologize. My name is Phil Silverberg. I represent the Appellate Zurich American Insurance Company. This appeal presents the issue of choice of law. In New York, the settled law is center of gravity or grouping of contacts analysis. The law in New York, particularly with the facts here, is not lex loci contractus. The respondents have essentially rested their case on a single fact, that the
The
domicile...
Providence capital is domiciled in Rhode Island, is that correct?
That is correct, Your Honor.
And the place of contracting was where?
The contracting, well, that, and according to the judge's order, New York, Massachusetts, and Rhode Island. The broker was located in Massachusetts. Zurich had an office in New York, and Zurich is also...
Policy also covers Rhode Island locations of Providence, Rhode Island locations of Providence as well, right?
Yes, it does, Your Honor.
Okay. And Providence, so their domicile is Rhode Island.
That insured's domicile is Rhode Island.
So why would not Rhode Island law?
This policy has other named insureds. The named insured loss here and is a respondent is Cheryl Wagner International LLC. Cheryl Wagner is domiciled in New York. Cheryl Wagner's offices are in New York. The loss that is the issue at issue in this litigation. This is a first-party property policy. It involved water damage in a showroom.
Counsel, isn't the domicile of the insured the dispositive? The domicile of the insured being Providence Capital, not the place that's located in New York.
And just to follow that up, I think that analysis would come from the Foster Wheeler case in 2006, where the court went through this, and well, we went through this, and we looked at certain factors, and we came to that conclusion that it wasn't necessarily the location of risk rule, but it was that the state of the insured's domicile, and then there were several factors that we went through. So if you could just talk about form your answer in that context.
Sure. Well, I have two questions that I think are kind of similar, so I'd like to answer them. First of all, this policy has a number of named insureds.
Yes, but both of them are in Rhode Island, 18 in Rhode Island, 4 in New York, including Cheryl.
The only insured who had an interest in this property, and this is a single event.
No, but you're talking about a policy that's multi-risk, multi-state, you know, and if you're going to do numbers, if you're going to use that as a factor, then the numbers favor Rhode Island.
I would respectfully disagree, Your Honor, and if I could address Foster Wheeler, because this court, the First Department, has distinguished Foster Wheeler on more than one occasion after the Foster Wheeler decision, and has raised the very significant differences between Foster Wheeler. Foster Wheeler was a liability policy. It involved 30 insurers, at least 30 insurers. It involved thousands of claimants, and it involved damages, asbestos damages all over the country, maybe all over the world. What the court said, we can't do, if you do the conflicts, the grouping of contacts or the center of gravity, the only thing that really works is where the insured is located. Foster Wheeler is far different, and it's in our briefing.
Yes, but here, counsel, here, if you look at the domicile of the insured, it is the primary insured. It owns the policy, it pays the premiums, and it's entitled to any payments that come from Zurich.
Your Honor, and I would point you to the record 367 and 368, where the insured wrote a letter and said, Cheryl Wagner has the only insurable interest in this loss. Everything happened in New York. The loss event occurred in New York. Cheryl Wagner is a named insured under this policy too. This location is named under this policy.
But the insured is Providence.
The insured,
Cheryl is a named insurer under the Providence policy, yes?
Providence isn't insured, so is Cheryl Wagner. They're both named insureds under the policy.
I thought Providence was the company with Sure, yes, with Sure Realty, yes.
Oh, Providence,
Cheryl.
Washington, I'm sorry.
With Cheryl Wagner.
Providence, Washington is a named insured. It's the lead named insured. It's not the only, but if you look at the cases, Illinois.
Well, if you look at Foster Wheeler, the way I read Foster Wheeler, that would be, to me, persuasive that Rhode Island law should apply. Because under Foster Wheeler, you're talking about an aggregate of the interest. And again, when you have an aggregate of the interest, including the domiciles where the insured is domiciled, that would be Rhode Island.
And you're looking at which jurisdiction is most intimately concerned with the outcome of the case. That's what Foster Wheeler says, right?
Understood. So, and I would just commend to your honors, Illinois versus Zurich, Davis versus QBE, Worth versus Admiral, where they distinguished those cases where the named insured, and I believe it was Illinois versus Zurich, was Maryland. An additional insured, not even a named insured, was New York, but the loss happened in New York, and the court said, the First Department said New York law applies. When you aggregate the contacts, the grouping of contacts, the center of gravity, the list goes on. The loss event was New York City. The insured property was located in New York City. The name.
You have time on rebuttal. Thank you.
Thanks.
May it please the court, Dan Rabinovitz on behalf of Providence Capital LLC and also on behalf of Cheryl Wagner. Foster Wheeler was not overturned. It was distinguished. Zurich says that our argument is lex locae contractus. That is not the case.
Well, Foster Wheeler, as I said, seems to me would kind of dictate applying Rhode Island law.
Absolutely, and that's what I'm trying to buttress, Your Honor. The court should consider and weigh heavily where the first named insured is located. That was the term that some of you were searching for. It's first named insured. And just to complete the list, it's in the papers and in the record at 120, 121, but the first named insured is really the primary insured. And this comes from Zurich's adjuster's testimony at his deposition, Mark Graves. It's the owner of the policy. It's responsible for paying all the premiums. The first name insured is the only insured under the policy that has the authority to cancel the policy. Any payment under the policy that Zurich issues must be sent to the named insured. And in fact, when a payment was made, not enough, but a payment, it was Zurich who insisted that Providence Capital be on that check. And that's also in the record and in our brief. Any refunds have to be paid to Providence Capital. Only the first named insured can agree to any changes. All notices need to be sent to the first named insured. And again, and the record 121 to 122 is where Mr. Graves insisted, Zurich's adjuster insisted that Providence also be named as a payee because the policy states the first named insured shall be the payee of any payment of claims. In addition, payment for the premium that Providence dutifully paid was obviously made from Rhode Island. And so with respect to the other insureds, the court is absolutely right. There were 26 insureds in total. 18 of them are from Rhode Island, 18 of them. You can't tell me that when Providence LLC contracted with Zurich that both parties didn't understand that this was a policy heavily weighted to risk in Rhode Island. And with the combination of the first named insured and the fact that Providence is domiciled in Rhode Island, with all due respect to my adversary and his client, that should be the ballgame.
And Shore Wagner, their showroom is here in New York. They are the only ones who are domiciled in New York or have a connection to New York, right?
Correct.
Everyone else is Massachusetts or Rhode Island.
Correct.
But the majority is Rhode Island.
Vast majority, yes.
Vast majority Rhode Island. And more importantly, Providence Realty is Rhode Island.
Yes, and the only other thing
Providence Capital, excuse me.
The only other thing I'd like to make sure that the court hears from me is with respect to the Illinois national case that my adversary has cited, that court made clear that Foster Wheeler was not applicable because that case involved a non-party who was added to an insurance policy as an additional insured to cover a specific risk. That's not the case here. I will say this, Your Honor, I've read a lot of these cases. There's not one case that has cited any of these attributes of the first named insured the way this policy cites and the way this record shows. And that is another distinguishing factor that this court should find significant, and you should follow Foster Wheeler, and you should uphold the decision of the learned trial court and affirm the decision.
Thank you. You have 1 minute in rebuttal.
Thank you, Your Honor.
So, counsel, the big difference between Rhode Island law and New York law is the protection of Rhode Island, protections afforded in Long Island with respect to bad faith, right?
It is about the bad faith. That is the difference. And as we've said, New York has a governmental interest with respect to not extra contractual damages in New York for insurers doing business in New York for property in New York. If I could just quickly speak to the First Department cases. Davis v. Partners applied New York law where the loss occurred in New York, even though the insured was New Jersey. Illinois National applied the grouping and contacts test, and it was the Maryland insured, but the additional named insured was New York, and the loss happened in New York.
The parent has subsidiaries that are located in several states, correct?
Yes.
Okay, and so if we accepted your position, would that mean that this single insurance policy would be subject to interpretation of each of those states as opposed to having one uniform, one law consistently applied to any claims arising with respect to any of the subsidiaries?
Well, I would say it does depend on the nature of the claim. This is one particular loss that happened in New York, and if I could just have 20 more seconds, if your honors look at record 367, 368, this is a letter on Cheryl Wagner letterhead. Pursuant to our prior conversation, with regards to the advance payment of $1 million, the check should be made payable to Cheryl Wagner LLC. Neither of the other entities has an insurable interest in the damages which occurred. Everything happened in New York. Yes, the lead named insured has to be named on the policy. That's a mechanical issue, but that should not dictate what law applies to a loss where the center of gravity is in New York.
Thank you.
Thank you.
Saxby Rent-A-Crate Enterprises. Yes.
Good afternoon, Your Honors. Jack Watkins from Kahanafeld for the appellants. I'd like to start by drawing attention to a mistake in our brief. On page 5, we have a citation to the Oates versus New York City Transit Authority case that's missing a flag that the quotation is from the dissent. It's an innocent mistake. The language is still good law. It was just a convenient place.
Let's talk about the affidavit of the driver, the defendant driver. How did that present a non-negligent explanation for this accident?
I think that it does, Your Honor. I think that what Mr. Machiri says is that he had done this about 20 times before, that he knew that plaintiff was familiar with what he was doing, and that he had no ability to anticipate that plaintiff would position himself in the zone of danger the way that he did. And that's the non-negligent explanation. Under the vehicle and traffic law,
The non-negligent explanation is that he didn't know what the plaintiff was doing?
he had no ability to anticipate that the plaintiff would choose to stand in the narrow space that was intended to be left between the white van and the truck.
I don't want to be facetious, but did he not have eyes? Because he is backing up, but I'm assuming he's checking the mirrors, et cetera, and also there are folks who are guiding him. So I think we've all viewed the video. If you look at the video, there was substantial space on the other side.
There was definitely space on the other side. He's not aiming for that other space. You're absolutely right.
What do you mean he's not aiming for that other space?
He's clearly trying to pull parallel to the white van.
Yeah, exactly.
also
But
knows
there was substantial room for him to do so.
Even before he continues to move back to parallel with the plaintiff,
It wasn't parallel. He sloped to the right, and that's where the problems begin. When
trying to pull parallel with the van. I misspoke. Not with.
Right, he's trying to pull parallel with the van, but again, there was substantial space for him, room for him to do so without coming into contact with the plaintiff.
Absolutely right. Absolutely right. There's plenty of space on the left. I can't deny that. That's obvious in the video. But nevertheless, he's trying to fit where he's trying to fit because he's been signaled
there was
by
no
plaintiff.
there was no lack of space to fit into.
Right, my point was that he didn't have to get that close. It wasn't necessary for him to get that close to the white van. There was so much space on the other side that there was enough clearance for him to go totally over.
Well, I think he's being signaled by the plaintiff as well as by a third person who's also present on the video
Counsel, if
signaling.
he's being signaled by the plaintiff, he can see the plaintiff and not squash him.
Well, we can go blow by blow with that.
But we saw what happened to the van.
Right, and that
The
was
van
my
rocked.
And that was my point in terms of, history or whatever, prior experience with the plaintiff, that's all well and good, but when you look at the video, again, whatever that prior history was or whatever the plaintiff did in the past, this is a separate situation wherein there was so much room on the other side that he need not have come that close to the white van.
Well, can I address two separate points that I think you're making? First is the question of whether he could have pulled in a different location. Obviously, he could have done that.
Well, here's the thing. He could have put that in his affidavit. I wasn't able to use the 6 feet of space that was to my left because of whatever reason. That's not there, and it's really not apparent from the video either.
I agree that it's not in the affidavit, but I am the non-movement on this. So just because something's not established in my affidavit.
You have to put forth a non-negligent explanation. That's the burden.
Correct. The non-negligent explanation here is that he had no idea that plaintiff placed himself where he did. What the video doesn't show is, respectfully, it does not show my client's point of view. It does not show what he can see in his mirrors, and it does not show what he's looking at. He's clearly being signaled by the third individual on the video. He's clearly looking at that person who's signaling for him to back up. And lest we forget, he doesn't actually hit the plaintiff while he's backing up. He hits the plaintiff while he's pulling forward. So let's unpack this a little bit.
Okay, but under vehicle and traffic law, though, when you are backing up, when you're putting your car in reverse, don't you have an obligation to see?
To see what's there to be seen, Your Honor. It's just a rephrasing of the common law.
Yes.
It's not like.
But you just said that he could not see what was behind him. He could not see the plaintiff, and that he was being guided by the other gentleman.
Yes.
So
no.
Is it safe to back up on the vehicle and traffic law if you cannot see, and rather you are being guided by someone else?
No driver has the ability to see what's in their blind spot, Your Honor. So it can't possibly be true that everyone who backs up without being able to see the totality of what's behind them.
I have a camera in my car,
so
so it shows the blind spots as well. But the thing of it is, in this particular case in the video, you see that individual banging on the side of the truck, and you see the plaintiff as well banging on the side of the truck, and you see them motioning. First, you see them motioning for him to come back, and then once he is almost making contact with the plaintiff, or what appears to be making contact with the plaintiff, the gentleman is banging on the side of the truck to stop.
Well, if we can go all the way through it, you see the plaintiff move the vehicle back, then the plaintiff turns his back to the truck, steps into the truck's path, then he steps up against the van. While the truck is backing up, the plaintiff, before it makes contact with him, leans in like this and puts his hand up.
I don't know that you can state that the plaintiff moves into the path of the van. It seems as if the plaintiff moved to the side, in the path of the truck. It seems as if the plaintiff moved towards the van. And again, as my colleague said, you got at least 6 feet of space on the other side, which would be to your client's left to move to. But you have time.
At the start of the video, plaintiff is on the driver's side, he crosses to the passenger's side, so obviously he crosses through the path.
Yeah, he passes to the passenger side because there's the space on the driver's side. But you have time in rebuttal.
Thank you, Your Honor.
Good afternoon. May it please the court. Michael Levis for the plaintiff respondent.
Counsel, so we have seen the video. My recollection is that the body signals, the hand signals, indicated to the driver to move straight back. Is there any point where the hand signals or the arm signals, whatever you want to call them, indicate to the driver to cut over to the right?
I do believe you see at second 42 and 43 of the video, might not exactly be a direct hand signal, but as the court had mentioned, both the plaintiff and the helper of the defendant clearly banged on the truck indicating to stop. I believe that there were some statements that the defendant himself heard somebody yell, "Stop." That is an indication, stop.
But other than the banging, which is after the hand signals, is there any point in time where the hand signals are telling the driver to cut to the right? Cut the back of the truck to the right?
I do not believe that is the case. But
Counsel, given how much we're getting into the weeds of how this transpired, was your motion premature?
it was not.
There were no EBTs taken yet.
Correct. The appellant has failed to provide what information would be gleaned from depositions.
Well, he says in his reply that the video evidence but possibly gives rise to something called the dart-out defense, which he takes from another case. And he says that distinguishes it from Fernandez, which is a case that you rely on.
Correct.
So what about asking the plaintiff questions about, did you move around too much? You know, like, well, why did you go from one side to the other?
How can we argue that this is a dart-out case if the defendant is clearly following the direction of the plaintiff into the loading dock? It's not as if someone's driving and a pedestrian darts out of the street. He clearly knows that. The plaintiff is there. He clearly has to.
I guess at some point in time, the argument could be made that your client does move. He's out of sight, right? He's no longer within the defendant's sight.
Correct. And the standard essentially should be if you don't see him waving you back and he's out of your vision, whether it's from your mirrors or otherwise, you should not continue to proceed.
Standard should be or standard is?
I believe that it is.
Well, VTL 1211 says you can't reverse, you cannot reverse a vehicle unless that movement can be undertaken safely.
That is
right, and that was my point. But again, the plaintiff and the other gentleman are assisting the defendant in terms of moving back, right?
Correct.
Thank you.
If there are no further questions, thank you.
I'd like to just take that up. I think that the answer is that what my friend has just argued is what he thinks the standard should be. But I also think that Rodriguez v. City of New York did not change the burden a plaintiff bears in carrying a prima facie case. And what that prima facie case requires is both breach, what we often call negligence, but breach of duty, and proximate causation. Those things both need to be shown, and they need to be shown as a matter of law.
Right,
which
but
means
with
that
respect to the latter, Rodriguez made it clear the plaintiff needs to show prima facie that the defendant's negligence was a proximate cause, not the sole proximate.
Absolutely right, Your Honor, and I can't argue with that, nor would I want to, because I think Rodriguez was rightly decided. But what I do think is that nevertheless, what changed was not whether proximate cause has to be established by the moving plaintiff, but what degree of proximate cause had to be decided. In other words, I don't think that in Rodriguez, the Court of Appeals held that what this court or motion court should do is just look at the facts of cases and say, you know what, a jury is more likely than not to divvy up the negligence among both parties here. So let's, at a minimum, grant summary judgment to plaintiff, because there's going to be at least 1%. There's still a burden there. The moving plaintiff still needs to show that there's absolutely no way that a jury could interpret what the facts in the record are to find my clients to be non-negligent. Absolutely no way. We've just been debating whether the hand gestures were back or to the right. We've just been looking second by second, actually, in the briefs at that video. We've just confused, all of us, whether plaintiff was struck while the vehicle was in reverse or while the vehicle was pulling forward.
I'm not really confused.
Well,
I'm just speaking for myself.
That's fine, Your Honor.
I'm speaking for myself, but I do.
I don't even know if we're debating.
I think we're asking, but I do understand your argument.
Can I make one more point? And I apologize. I know I'm way over time.
One more point.
I didn't write the appellant's brief, but the appellant's brief concludes a point 2 saying that alternatively and at a minimum, in any decision affirming, there should at least be language clarifying that the issue of contributory negligence is live. Plaintiff's brief contains a 1-paragraph argument that contributory negligence should be dismissed. There's no basis for that on this record. Plaintiff clearly.
Counsel, that's for the trial judge to determine. Exactly. You know, we don't have to say, we don't make those kinds of declaratory judgments ahead of time. That's like an advisory opinion. So make that argument to the trial judge.
That's exactly what I want. I just want it to be clarified that in affirming, if you do affirm, there is no decision whatsoever on contributory negligence.
Thank you. Thank you both. McLaclin v. Air and Liquid Systems Corp.
Good afternoon, Your Honors. Josh McMahon. May it please the court. As this court itself stated in the Ghibli case, the question on summary judgment comes down to whether the information known to both parties at the time of the release precludes the possibility of mutual mistake. In other words, if there is any possibility that there was a mistaken belief as to the non-existence of a presently existing injury, summary judgment should be denied. The evidence provided in opposition to summary judgment here
sounds like you could drive a truck through any release ever, counsel. That's much too broad a statement of the standard. Here you have a very broad release, a release from any and all claims of any kind whatsoever that they ever had or may ever have as a result of the alleged exposure to asbestos. The last 3 words are very important. You get asbestosis from exposure to asbestos. The whole agreement talked about the verdict plaintiffs versus the non-verdict plaintiffs, and your client was a non-verdict plaintiff. He had to provide information about asbestosis or mesothelioma, so it was in front of everybody.
I'll answer Your Honor in a couple of ways. First way would be Mangini, the controlling court of appeals case on this issue, expressly talks about this kind of general standardized language. I mean, Mangini itself was dealing with a release that had very similar language, any and all. But if you look at the actual release itself, and I agree, the release in the language therein says what it says. And we've submitted it in our papers and you have the release. But I would also point to a section of the release where it arguably says something else, and that's on page 526 of the record. The release talks about the amount paid to plaintiffs being fair and adequate consideration for a complete release of the claims asserted against Loco in the federal action. What does that mean, especially to a layperson? When we're talking about summary judgment and we're talking about affording every reasonable inference to the plaintiff, construing all of the evidence in the light most favorable to the plaintiff, we have to ask ourselves, referring again to Ghibli, is there any possibility that there was a mistaken belief? We provided evidence in opposition to summary judgment that included testimony from plaintiff that he believed his prior federal lawsuit, and by extension, the release he signed that was pertinent there too, was for asbestosis. Not mesothelioma, not lung cancer, not GI cancer, or any other kind of cancers.
How does the situation, how do the circumstances in which your client found himself differ from the situation presented in Langhorne?
Sure, Your Honor. In Langhorne, There are a lot of factual similarities. I think we're dealing with the same diseases. We're dealing with a federal release as opposed to a state court action. But there is a major distinction. In Langhorne, this court said that the plaintiff there was an absence, not that there was an absence of evidence of mutual mistake. We have evidence. Not only do we have evidence that courts across the state have considered.
You're saying mutual mistake because of the dollar amount and it's being so low?
No, Your Honor. No, Your Honor. The mutual mistake here has to do with the non-existence of a presently existing injury. When Mr. McLaclin signed the release for asbestosis, he had already been exposed to asbestos.
But that wasn't a present existing injury, right? That was something that he developed later.
He developed asbestosis and brought a federal lawsuit for it, Your Honor.
I'm talking about the mesothelioma.
He later developed mesothelioma, as we allege, from the same exposures. So you have a situation where an injury occurred, two injuries occurred, asbestosis and mesothelioma, but only one was known, and furthermore, only one could have been known.
I would totally agree with you, but for the release, which my colleague read, and it states related to asbestos exposure. You know what? If those words relating to asbestos exposure, if they were not there, then perhaps you would have a case. But I mean, I could understand your argument a little bit more. But the release is so broad, and it takes into consideration so many different types of injuries related to asbestos exposure. Unless you can show, well, that wouldn't even help. I was going to say, unless you can show that this was unrelated to asbestos exposure, but then that wouldn't help you.
I guess I would just answer, Your Honor, by saying that Mangini talks about this, that an unknown injury is necessarily not in contemplation of the parties. It's almost as if it's not contemplated as a matter of law. He did not know about it when he signed the release. He could not have known about it. And because of that, there was a mistaken belief as to what he was agreeing to.
But didn't Mangini kind of talk about symptoms also, and the symptoms were unrelated or the symptoms were unknown at the time?
So Mangini drew a very sharp distinction, Your Honor, between injuries unknown and a mistake as to the consequences, sequelae of injuries, right? So mutual mistake does not turn on whether or not the injuries resulted from the same accident or exposure, nor does it depend on whether the injuries occurred in the same area of the body. When a
I think basically your argument is that, and I understand this, is back in 1993, perhaps we did not know what the consequences or the possible consequences of the exposure was.
I don't know if that's necessarily our argument, Your Honor. I think that our argument is that, and to address Your Honor's point about the release saying and everyone having, each individual plaintiff, and there were 270 of them, had to submit their own individual medical documentation establishing what disease they had. That's the settlement agreement. The general release, which is what our clients actually signed, is for asbestosis. Just because mesothelioma was contemplated amongst the diseases that other individuals were releasing Lilco for, doesn't impart knowledge to our client about whether or not he would. In fact, it couldn't have. He had asbestosis. He had no reason, or he could not have known that he would develop mesothelioma 30 years later. And that is evidence of mutual mistake. There are cases that we cite in our brief. We do distinguish Langhorne, but we cite the Lang case from the Fourth Department, the Ghibli case, which says that if a plaintiff can demonstrate that a later injury was of a different nature than that of which both parties believed at the time of the release, a claim of mutual mistake is made out. The Billy case out of the Fourth Department, the Corolla case out of the Third Department, all of these cases stand for the proposition that we're submitting. And I'll say for rebuttal. Thank you.
Good afternoon, Your Honors. May it please the Court. Douglas Bone from Cullen and Dyckman on behalf of the respondent, Long Island Lighting Company. Thank you, Your Honors, for sticking in on a long afternoon. Counsel, in his argument, just said it. He just said, just because mesothelioma was contemplated in the prior settlement. That's Mangini, Your Honor. The importance
but not
of
contemplated with this particular plaintiff, right? I think that was the ending of his statement.
The settlement agreement that was executed contemplates mesothelioma as well as other asbestos-related diseases, as is mentioned by counsel, for this plaintiff as well as others. Now, here, on a mutual mistake claim, the releasee seeking to overturn the release bears both the burden of persuasion and the burden of proof here. So that is upon them to demonstrate that somehow Mr. McLaclin did not understand what he was doing. There's no evidence of that. We have the settlement agreement. We have the general release. We have the language of Mangini. We have his testimony from 2002. Counsel mentioned that. He simply said, I got asbestosis and I brought a prior federal action. He didn't say it was a limited release. He didn't say I held out mesothelioma. He didn't say anything like that.
Well, unfortunately, it may just be, or not unfortunately, it is what it is. It may be that the releasee has one view of what the releasee is releasing, but then the releasor has a different view, and that's only unilateral mistake.
Correct, Your Honor, and that doesn't win the case here for the appellant, whereby the argument is for a mutual mistake.
So how would a person in your friend's position, how would they raise an issue of fact in that situation where they say, here's some evidence that suggests the releasee was not clear as to what he or she was releasing? How would they satisfy the other side of the other part of the equation that the releasor was laboring under some mistake?
Your Honor, obviously that would be a different case, and to be quite honest with you, I'm not sure. What I do know here is that we do have the plain and unambiguous language of both the release as well as the settlement agreement, and that, even before we get to Mangini, that needs to be our starting point. I'd respectfully suggest that we don't need to get to Mangini here, because we do have multiple points of that language in both the release and the settlement agreement whereby whereby the plaintiff had capable counsel. So I don't know that we need to even get there, but because I believe one of my colleagues in a prior argument I remember hearing said, game over. I don't want to be crass about it, but ball game over there. However, if we do get to Mangini, if we do look at it, where Mangini starts, well, obviously where Mangini starts is that the execution of a release is a jural act whereby it should not be disturbed unless there's some sort of grave situation, which is the starting point. But if we start digging deeper into Mangini, again, you mentioned it before as I opened. As long as it was contemplated in the release, contemplation is that key issue here. And the evidence, now, Your Honor, to go back to your question, how it would be proved, I can't give you every situation. I can only deal with the one here. But when we deal with what has been presented here on the documents and anything else that has been submitted, the conclusion, as Justice Silvera held, that the language is clear and unambiguous and that mesothelioma was contemplated in that original settlement, that's really where we end up. Of course, there is, Your Honor brought up the idea that some of this language has been in releases many times, and that you could, you'd never have a release that can be relied upon by either party if we allow it to be undone here.
Well, Justice Gonzalez asked your friend about people versus Langhorne.
Yes, sir.
Did your friend persuasively distinguish Langhorne?
No, Your Honor, I don't think so. My colleague mentioned Lang, which is a JHO decision from the 4th Department, which actually expressly says this isn't Langhorne, and notices and writes in the footnote, excuse me, if I may just finish Your Honor's question, puts in the footnote that Langhorne controls in the 1st Department. That is this court's law. I return to the key fact in Langhorne, which would be a federal prior action for asbestos exposure resulting in asbestosis, which later had a release that was upheld. So, Your Honor, to answer your question, I think Langhorne is unaffected by Lang, and Langhorne certainly controls here. Thank you.
I just wanted to briefly address Your Honor's point about the unilateral issue. I think plaintiffs would be hard-pressed to find a defendant that wouldn't want to argue the position that defendants are arguing here for for our interpretation. But I think that's why Mangini, in the cases that have followed it, have stated that evidence of unknown injuries at the time that the parties executed the release demonstrate that they're not necessarily in contemplation of the parties at the time of settlement. This notion that neither side could have known, and evidence that there was an unknown injury, as we submitted in our papers.
Is that what Mangini states, though? Evidence of unknown injuries? I thought, again, Mangini spoke about symptoms of injuries.
Mangini had to do with I think it was an auto accident, and the individual plaintiff that was hurt had injuries to, I believe it was her shoulder, and then she described pain to her hip.
Right.
They brought an action and signed a release just for the injuries to her shoulder. 6 months later, they did an exam and found out that there actually was a significant injury to her hip. And in that instance, because that injury was, even with testimony that there was pain, in that instance, there was evidence that there was that they didn't know about the injury. They didn't know about.
You're arguing that asbestos has nothing to do with mesothelioma?
They are mesothelioma. It's a tough one, Your Honor. I struggle with it too, and I say it all the time. Asbestosis and mesothelioma are etiologically distinct diseases. You can get one without the other. They have different periods of manifestation. Asbestosis can crop up years after an exposure. Mesothelioma often takes 30, 40, 50 years to manifest. They are different diseases.
But don't they all flow from exposure?
They certainly do, Your Honor. They certainly do. They all flow from exposure to asbestos, and we even allege that they, in this instance, flowed from the same. But Mangini, in the cases that follow, say it doesn't matter if they come from the same exposure. It doesn't matter if it doesn't even matter if it's in the same part of the body. What matters is the actual injury, and the actual injuries here were distinct.
Thank you.
Thank you, Your Honor. I thought they forgot about us. They forgot about when we were supposed to be third from the end, right? I think. I mean, I know they can go either way.